Ready to go.
All right, I'm gonna let them in. Just give them a few minutes. We have a lot of participants, so I have to make sure everybody gets in.
Is that person still there?
She can sit there. Mute myself.
I have a couple people.
You got 2 iPhones, I see.
Yeah.
Could we ask them to identify themselves?
Were you asking
Mark.
for?
Mark,
Yeah.
can you just mute yourself for a second? I'm gonna call you.
Sure.
Okay, I think everybody's in from the waiting room.
Okay. Is there any councilmen online? If they are, please disconnect. Ready? Pledge allegiance to the flag.
1 second.
Pledge allegiance to the flag of the United
States of America, and to the republic for which it stands,
States, one nation, under God, indivisible, with liberty and justice for all.
Justice for all.
The 48-hour notice as required under the Open Public Meetings Act has been met, as notice of this meeting was emailed on September 28th, 2020, and published in the Asbury Park Press, the Co-Star, and the Coaster. A copy has been placed on the bulletin board in the Borough office, and a copy has been filed with the Borough Clerk. Mr. Affuso.
Here.
Mr. Quinlan? Mr. Quinlan, if you're participating by phone, you have to unmute yourself. I don't know if he's with us yet. Mr. Correa is excused this evening. Mr. Wade?
Here.
Mr. Mayor?
Here.
Ms. Phillips is not with us this evening. Ms. Rosenberg?
Here.
Mr. Critelli?
Here.
Ms. Brunel? And Chair Rosenberg.
Here.
And also present this evening, Mark Hitchcock, Attorney of the Board, Gerald Frieda, Board Engineer, and Christine Bell, our Board Planner.
I'd like to make an announcement that the Petrino case will not be heard today. It wasn't noticed correctly. And if they renotice, they will be on the agenda for December 17th. So anybody who's interested in that case, does not want to stick around, you're welcome to leave.
No.
No.
I'm sorry, I just want to be clear. I'm here for the 217 McCabe Avenue
That's
issue.
that's the one. That's the one that's gonna be, if they renotice, it'll be December 17th.
Oh, geez. Okay.
Yes, there was an error. There was an error in the notice,
Yeah.
and the notice didn't make it into the Asbury Park Press in time. So we had to move them to the next available meeting, which is our December meeting.
December 17th.
Yes,
If
Okay.
tentatively December 17th, but I just found out about it today, so.
Okay. All right. Thank you.
you'll be
Okay.
renoticed.
All right.
That's why I'm on as well. Okay.
So, okay, hey,
Thanks.
let's, I appreciate people being interested in asking questions, but Chrissy, just want to go over some procedures on, because I think we have a couple of applications tonight. We cannot have people just speaking out. So if they have to be recognized via the Zoom meeting, could you just go over how they do that? And then once you do that, Mr. Chairman, if you could read, the rules of our meeting. So,
Okay.
I would just ask that if you're participating via video and via Zoom and video, that you either raise your virtual hand because I can see it, or you raise your physical hand if you can't find the area where to raise the virtual hand. If you're participating by phone, if you need, when we call for public comment or questions, you need to unmute yourself so that you can be heard, because I can't see you and you're not able to raise your hand. But please try to keep yourselves muted during any testimony, because we get a lot of background noise and it's really hard to get a clean record when there's people shuffling papers and dogs barking and doorbells ringing and phones ringing. So please remain muted until it's your turn to speak.
And we have a resolution for procedures. The meeting will be recorded for transcription purposes. No member of the public shall yell from the audience, speak out of turn, as it will disrupt the official record. Once the Board of Adjustment accepts service on an application, the applicant will proceed to call the witnesses. The applicant or their attorney will first examine each witness. Next, the members of the board will ask questions and cross-examine the witness. Finally, the members of the audience will be entitled to cross-examine the witness, asking questions only related to the testimony given. This is not the time when members of the audience will be given testimony, present evidence, or make comments, and please use the virtual hand or hand during this. Once the applicant has finished presenting all evidence and all witnesses, any interested member of the audience may then make comments, present evidence, and testimony. There will be 5 time limit for each audience member to speak. As requested, comments shall not be repetitive. All members of the audience who intend to give testimony must do so under oath. The applicant or his attorney may cross-examine you upon your testimony. The board may also call its own witnesses, present its own evidence with respect to any application. If you require more than one hearing to complete an application, the application will then be carried to a future meeting, which will be announced at the conclusion of the hearing. The Board of Adjustment will attempt to adjourn the meeting or a reasonable hour. Therefore, under no circumstances will a witness be called to provide testimony after 10 p.m. Thank you all for help following these rules. Approval of the minutes. I make a motion, we approve the minutes from the September 17th meeting.
Second.
Mr. Critelli,
Yes.
Ms. Brunel,
Yes.
Mr. Afuso,
Yes.
Mr. Wade,
yes,
Mr. Mayor,
Yes.
and Chair Rosenberg.
Yes. I make a motion, we memorialize Resolution 20-20-14, approval of bulk variances for Block 3520, Lot 25, 412 Lorraine Avenue.
Can I just make a correction to that, Chair? I had listed, I wasn't sure, and I didn't have a chance to speak to Mark before he went away. I had listed the decision as two separate resolutions. Mark actually combined them into one resolution.
Correct.
That was for the affirmation of the appeal of the zoning officer for the same property, as well as the bulk variances that were required.
So it's one approval.
So it's one approval under Resolution 2020-14.
Okay. We have a second.
Second.
Mr. Critelli,
Yes.
Ms. Brunel? Ms. Brunel?
Yes.
Okay. Mr. Afuso?
Yes.
Mr. Wade?
yes,
Mr. Mayor?
Yes.
And Chair Rosenberg.
Yes.
Okay.
First case tonight is zoning board application 20-11, Mark and Jeanette
Snyderman.
Schneiderman. Block 88, Lot 16, 508 Bradley Boulevard. Where are they?
Right here.
They're waving.
Okay. Do you're going to present your case?
Yes, we are going to present the case. So we are.
Before we do
Just
that,
before you begin, sir,
Yep.
I have to swear you and you and your wife,
Yeah.
okay? Along with our professionals, Ms. Bell, Mr. Frieda, Mark and Jeanette, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth tonight's proceeding?
I do.
Thank you. Thank you.
present your case, sir.
Okay, thank you everyone for hearing our case. And so the case is a request for a hardship variance related to the minimum required distance between the primary structure, being our home, and the existing accessory structure, which is a garage that we have in the backyard. And we're adding in a shower, an outdoor shower in the backyard. The existing setback between the existing house and the structure, which is the garage, is non-conforming. It's under the existing code. It should be 20 feet, but it was a non-conforming existing use, which was 12 feet and about 6 inches away from the garage. And the request for the variance is related to, in order for us to place the shower anywhere in the backyard area, it would create a further non-conforming use because we would be less than 20 feet from the existing garage. So we have found a spot where we could put the shower. It really, anywhere we put it, we think would exacerbate that non-conforming use. So we're looking for relief from that or setback requirement. The shower has been designed to conform with the code, and we'll have a wood shower on top of a slab with a drain with hot and cold water, and it will end up being about 12 feet 8 inches away from the garage, which is a greater distance than where the existing house is actually, which the house is about 12 feet 6 inches. This will be 12 feet 8 inches the way it was designed, and it was placed in a location in a manner that would allow us to connect with the existing sewerage system and the drain, because there's actually on the wall where it's going to attach to the house, there is an existing bathroom. So there's already plumbing on that wall, and we're tapping into that same plumbing line and sewer. So, we've provided the documentation and the drawings as required for the committee. And, we don't really have another location where we can put it, so we're seeking relief from that setback requirement. So I don't know if there's other information or questions I could answer, but that's our request.
Mr. Chair, this is Jerry. May I speak?
Yes, Jerry.
Okay. In regards to the testimony, they're absolutely correct. There is really no better place to put the shower on the property than where they're proposing it. It's a negligible variance, as their portion of their house is almost the same distance away in separation. It's a little over 12 feet. Still plenty of room to get in and out and around there. But they don't really have much of an option to put the shower anywhere else. And they're taking advantage of a cutout in the building. So I do agree that it is the best location for the shower. They also had air conditioning units on the one side that we picked up and we weren't sure, and they were kind enough to send us over a copy of their zoning permit that allowed them to put them there. So the only real issue is the shower and the separation between the buildings, and there's really not a whole lot they can do. And I think they qualify for the D variance that they're seeking.
Anybody else on the board?
Just I have one question, Mr. Chairman. And Mr. Frieda, the air conditioning units are in the setback?
They're very close, but I don't have all the information I would need to know for sure, but they were on the site plan. So we questioned that, but they did have a zoning approval to put them there. So they may have been replacing ones that were there already before the zoning was in place.
But we have no testimony to that or no evidence to that fact.
Well, there's really no request for it. I only bring it up because it was in my letter and I wanted the board to understand why it was.
And they exist right now?
Yes,
Okay, that's what's curious.
yes.
Any other questions from the board? Any questions from the general public?
And please raise your virtual hand or your physical hand, or unmute yourself to make yourself known.
No.
Any questions or comments? I'm not seeing any.
Okay. Mr. Snyderman, would you like to make any more comments?
I just had one thing I wanted to ask.
Okay.
On where the door is the door going to be on the against the house side of the shower? That's what it looks like on the drawing.
Yes, the way that the shower was designed, it's attached to the, I guess, western side of or the eastern wall over there in that cutout. And then there's a little spacing between the southern wall of the house and the shower so that you have a little bit of a walkway and then you enter the shower through that door. Correct.
There's enough room for you to navigate that.
Yes, there is. Our designer made sure that was the case.
Okay, good. Thank you.
Thank you.
Mr. Fried, is that all correct?
Yes.
Okay. Any other questions from the board? Any other questions from the general public?
I'm not seeing any. A lot of people aren't participating with video, so I'm not too sure.
Okay. Any comments from the board? Any comments from the general public?
I do not see any. No hands.
Mr. Steiner, would you like to make a conclusion?
No, other than to say hopefully the case was clear and we appreciate your consideration of our request.
I make a motion to approve the application for Mark and Jeanette Schneiderman, Block 8816 at 508 Bradley Boulevard, to an applicant seeking variance for minimum distance to instructions in order to construct an outdoor shower.
Second. Go ahead, Ray.
I'll second it.
Okay, Mr. Wade. Mr. Critelli,
Yes.
Ms. Brunel,
Yes.
Ms. Rosenberg,
Yes.
Mr. Afuso,
Yes.
Mr. Wade,
Yes.
Mr. Mayor,
Yes.
and Chair Rosenberg.
Yes. Good luck and go through the proper procedure. You gotta wait till the next meeting before you could do any filing.
Yeah, so we'll have a resolution prepared for the next meeting, so congratulations.
Thank you,
Thank
Brad.
you.
Thank you very much. We appreciate it.
Mr. Kittredge, you're on.
Christie?
So, hey, Chrissy, I believe Mr. Quinlan,
Yes, Mr. Quinlan arrived at 6:50, but he missed most of the testimony, so I was going to note that for the record for the next application.
okay, very good.
Now,
Or if you want to advise everybody what the next application is.
the application is Beth and Howard Coppola, block 78, lot 14, 306 Monmouth Avenue.
So, Mr. Chairman, we're back on the Kotler application. And if you recall at our last meeting, that we had an on-the-record discussion with Mr. Stone and Mr. Cohn regarding some legal issues. And there were a number of legal issues that were presented, and both Mr. Stone and Mr. Cohn provided legal briefs on the issues that were discussed. And earlier this week, we had a pretty extensive conference call regarding those issues. So I am here to report back regarding those legal issues. And I can tell the board before I do that, that I've reviewed the notice and the publication to the Board of Adjustment. And at this time, the Board of Adjustment can take jurisdiction in this matter. So at that August 20th meeting, which is the last time we met on the application, as I mentioned before, I asked the parties to provide legal briefs to address the issues before the board. And they've done so. I received a letter brief dated September 16th from Mr. Stone, Mr. Cohn, a letter brief on 9/30. Mr. Stone then sent a reply letter brief on October 1st. Additionally, Mr. Stone provided transcripts from the June 18th and the August 20th meeting. So as part of the discussion with the parties on our conference call, everything I just mentioned has been posted. If you go on on the website, the three briefs I mentioned and the transcripts provided by Mr. Stone, those two transcripts are available for review for the public. So since that is now the case, I would request that Christie mark those exhibits. There are 5, and mark those exhibits as B1 through B5 respectively, so that they are now part of the record of this application. All right. So I had the opportunity to review the material presented by Mr. Stone and Mr. Cohn, reviewed them, each brief and the issues with them at the conference call. And during that conference call, we had a free exchange of opinions, and I gave at that time what I thought were what I viewed as preliminary determinations, and I want to put those on the record. Their arguments are on the record. We've just, they've just been marked into evidence. So, so I'm going to go through the issues. Issue number one, Mr. Cohn requested a site inspection of the property. That was one of the issues that was briefed. So in my years in doing this work, that's the first time I've heard of this type of request. So my reaction is that each individual board member has the opportunity to go to a property, take a look at it, and in fact, oftentimes members of the board, in fact, do that. So I don't think there was anything extraordinary that would require a site inspection. The board members have the opportunity to do that, and they can avail themselves of that opportunity or not. It's not a requirement that there be a site inspection. I also think due to the pandemic conditions that it's not advisable to do something like that at this time. So that was my determination as to issue number one. Second issue, Mr. Cohn raised the issue of having George Waterman, the zoning officer, be produced for testimony. As many of you know, Mr. Waterman is no longer the zoning officer. He resigned from his position, I believe, or retired from his position. This board doesn't have the ability, he doesn't have an employment relationship with the borough, doesn't have the ability to produce him or to mandate that he be produced. Mr. Cohn or Mr. Stone are certainly not precluded from calling Mr. Waterman as a witness. If they choose to do so, that they are certainly entitled to do so, as long as it's like any witness, his testimony was relevant. So they have the opportunity to do that. It's not the, I don't know whose background noise is
I just
coming through.
muted them.
Okay. But it's not the obligation or the ability, actually, of the board to produce him. Issue number three, whether, this is another issue we discussed and was briefed, whether a conflict exists if members of the Board of Adjustment were appointed while the applicant was a member of the Borough Council. I think the parties agreed, and I agree, that no conflicts exist in that situation, whereby it is a mayoral appointment, and that is a mayoral appointment, and nobody provided, and I don't think it exists, any case law that would state that that's a conflict. So my determination is that that is not a conflict, and that those members would be able to proceed with hearing the case. Another issue that was raised was a conflict of interest regarding a statement by Deidra Phillips. In this instance, Ms. Phillips is no longer a member of the Board of Adjustment, so that issue is moot. Issue number 5, whether Dave Critelli must recuse himself due to comments made at a prior meeting prior to jurisdiction being accepted. So in reviewing the brief submitted by the parties, I found that the matter of Voce versus Hard Cheese AC LLC 219 New Jersey Super is dispositive. That decision opines that a board member can remain on a matter if he or she affirms his or her ability to be objective, fair, and unbiased. So I know Mr. Critelli is not muted, so I just have a couple of questions for Mr. Critelli and only for Mr. Critelli. Mr. Critelli, if you hear this application, can you be objective toward all parties?
Yes.
If you hear this application, can you be fair to all parties?
Yes.
If you hear this application, can you make any and all decisions without bias toward any party?
Yes.
And is there any reason you believe that you need to recuse yourself from this matter?
No.
Okay. So based on the Voce case and the affirmation by Mr. Critelli and reviewing the submission of both legal counsel regarding the comments which are in the brief from Mr. Cohn, I find that Mr. Critelli does not need to recuse himself, and he has affirmed that he will be fair and impartial, and I think he satisfied the requirements under the law and the requirements of service of the Board of Adjustment member of the Borough of Bradley Beach. Another issue that was raised and discussed in the brief is there a basis for moving this application to another jurisdiction, which was an interesting thing to review. But incidentally, both parties covered all the issues. I'm confident that the legal research was exhausted. And I think we all agreed there's no support in the MLUL or New Jersey case law for a variance application to be transferred to another municipality. So I think it's clear this application stays in the Borough of Bradley Beach, and it's also my understanding that the applicant desires it to stay there. I believe we're going to have a quorum for this application. But if for some reason we didn't have a quorum within the Board of Adjustment membership, then we would then go and seek out members from the planning board in order to fulfill the quorum requirements. So if that becomes necessary, that's the direction you go, but the jurisdiction stays here. So the last issue is a unique and sensitive issue. Since it deals with potential HIPAA disclosures, which we fervently seek to avoid, and the sensitivity of doctor-patient relationships. Both parties in their brief cited their case, and I agree the controlling case is Piscatelli versus Garfield Board of Adjustment. And in that, it discusses a balancing test between the right of privacy and the right of the public to have a fair and unbiased hearing. So in what is before us, we know that the applicant is a local physician. So in speaking with the parties, we agreed that I, as the attorney who has as attorney-client relationship with the members of this board, would speak to each of my board members to see if such a relationship exists, and whether that board member or board member's immediate family member has such a relationship. If such existed, we agreed that that would be a basis for recusal. So I've had those discussions with the board members. Because of the sensitivity of this issue, I am not going to reveal those, certainly not going to reveal those discussions with board members And in keeping with privacy protections, if any board member ultimately recuses themselves from this application, the basis of that recusal will not be placed on the record, just the mere fact that they would be recusing.
Mr. Kittrick, first, are you able to hear me? Can you hear
Yes.
me? Okay. Do you mind if I just elaborate on that briefly? I know that you recited the law of Piscatelli, which I agree with, but I want to make sure that the board knows that part of that decision, the mere presence of a doctor-patient relationship did not in and of itself cause a disqualifying event. The emphasis in that case, as you recall, is that the relationship had to be meaningful. And it was my opinion that therein lied the intrusive nature of the inquiry. And to that end, in order to have reached the point at which that inquiry would be made, which would not be made at the Zoning Board of Adjustment, the matter would have to be in litigation. There would be discovery in the form of sworn testimony and depositions, and the parties would then be able to really invade the privacy of the board member. It was the applicant's position that that was too intrusive, even though it was not an automatic disqualifier. And it was that reason, and that reason alone, that we agreed that if there were any relationship, to avoid that inquiry, that we would allow you to determine with the board member the appropriateness of a recusal.
And we've done that.
Okay. Thank you for allowing me to make that comment.
Sure. And Mr. Cohen, do you disagree with that?
Not at all, Mr. Kittrick. The phone conference was very professional and a wonderful transfer of ideas, and I think we came to the correct conclusion all around, and you've handled it very well tonight, sir.
Thank you. Appreciate it. Okay. So that actually went smoother than I thought. All right. So
let's be optimistic that the rest of the
sometimes you're pleasantly surprised. Anyway. Okay. So I think so. We're gonna, as I mentioned before, we have accepted jurisdiction, and at this time I have to ask if any members of the board will be recusing themselves from this application this evening for any reason.
Mr.
Mr.
Mayor?
Cohen has his hand up. I'm not sure if it's relative to what we were just speaking about.
No, right after this, I just had something I wanted to put on the record, but this is fine. This procedure should.
Okay.
Yeah.
Okay, because I put your hand down because I thought you were going to say what you needed to, but.
Okay.
Mr. Kittrick, I have.
Okay.
Mr. Kittredge, Mr. Rosenberg's also recusing himself.
Okay. So
Yeah, I asked who elected to be to recuse.
yes, it's Mr. Mayor and Mr. Rosenberg.
I believe Mr. Mayor had recused himself from the other two meetings as well.
I had.
So all right. So by my count, we have 6 board members who are present this evening and eligible to hear the application. Since our chair and vice chair will not be hearing the application, we need somebody to chair the meeting. And Mr. Refuso, would you be available for that duty?
I would.
Okay. All right. So,
Mr. Kitcher, can I ask you to, because I'm not familiar with the names of the remaining board members, can you tell me their names or have Christie give me their names?
yeah, Christy, sure.
Sure, it's Teresa Rosenberg, Deborah Brunel, David Critelli, Raymond Wade, Robert Quinlan, and Michael Affuso, who is now our chair.
And just so everybody knows, Mr. Quinlan is attending by phone. So you don't see him. Mr. Cohen, is there something you wanted to?
Yes, Mr. Kittrick, you made reference before to the exhibits. I just wanted to confirm that the exhibits from the June and August meeting would also be entered onto this record?
You talking about?
Yeah, I just want to make sure that all those, I mean, you just took jurisdiction now. I just want to make sure.
The transcripts.
No, all the exhibits that were submitted at the June and August meeting are still part of this record.
Okay, so.
I don't think we marked anything there.
Yeah, there's nothing marked at those meetings because we didn't accept jurisdiction.
Well, could we accept jurisdiction for those items now? I mean, those are important to the case.
So I'm not sure what they are, so.
My list was submitted, in June and in August. At both of those meetings, I submitted the exhibits and they are on the website.
All right, so Christy, just refresh my recollection. Is that part of what Mr. Stone and Mr. Cohen had said?
From the prior applications? The documents are still listed under those meeting dates, under June and August, I believe it was.
Yeah.
I think, if I'm correct, I think we submitted all of the applicant's exhibits. They were all pre-marked, and one or more of my experts will be bringing them up and referring to them.
Yeah.
I've given Mr. Murphy, our engineer, control of the exhibits. So if you have to refer to them, he can bring them up on the screen.
So I just want to be clear, we're for either party, Christy, were any of the exhibits marked?
None of the exhibits were marked. They were shared.
I think, I'm sorry, but I think what we do is when it's, Mr. Stone's turn or Mr. Cohen's turn, those exhibits that are loaded up here, you then have them marked and moved into evidence.
Thank you for the clarification.
Okay. Sure.
Thank you.
I turn it over to the chair.
Thank you, Mr. Kittrick. Just in opening, I know this is an issue of great interest to a lot of folks, as we could see who's called in. Mr. Kittrick has treated this with the absolute tact, professionalism, and I expect everyone in the audience to act the same way. Mr. Stone, please call your first witness.
Yes, I'd like to make a little opening statement, and I have a little bit of housekeeping to do.
So Richard, can you bring up the volume? I don't know if it's me, but
Hold on 1 second. Hey, Helen, I need a little technology. Hold on. Don't go away.
We wouldn't miss it.
He might just need to bring his, if it's a laptop, bring it closer.
Hold on, I gotta call my wife.
All right. Hey, Richard, while you're doing this, so we can move things along, we're going to swear some of your witnesses in, but let's swear in Mr. Cohn now, Mr. Frieda, and Ms. Bell. While you're doing your thing, you have to unmute yourselves. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth tonight's proceeding?
Yes, I do.
Okay, thank you.
Hold on, my wife is helping me. Now I'm unmuted.
No, it doesn't.
No.
Where is your microphone located? Are you using a laptop?
Yes.
Is there any way to pull the laptop closer to you? I know you probably have documents in front of you, but.
That's okay, I can do it. Can you hear me now?
Not that we can't hear you, it's just a little distant.
Okay, hold on.
Are you throwing your voice?
No, I'm as high,
Is it as high?
that's as high as it can go. All right, let's try. I'll try to speak up and I'll project my voice.
There we go.
Thank you, Mr. Stone.
Don't be
Floor
So,
is
shy.
Mr.
yours.
Stone, can you just, because I don't want to miss anything, who are your witnesses tonight? I want to swear them in and then you make your statement.
Yes.
Okay.
Mr. Larry Murphy is our engineer. Miss Allison Coffin is our planner. And Mr. Alfred Trevino is my architect. And I'm told that they're all in the meeting.
Okay, so if they would raise their right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth tonight's proceeding?
Yes, I do.
Okay. Thank you.
I do.
Al?
I do.
Okay. All right. Mr. Chairman, let me just start off by, again, introducing myself. My name is Richard Stone, and tonight I'm privileged to represent the Cotlers in their application. This application has been pending for a while. It comes with some unique considerations. If you recall, just before the June meeting, that was the first time that I was introduced to Mr. Cohn. He raised an issue at the time in regard to a notice. I reviewed the notice on the June meeting. I addressed it with Mr. Kittrick. Frankly, I believe that the notice was adequate to proceed with the meeting that night, but it left open the possibility that after a long and arduous application process, if an appeal was taken after an approval, I did not want to have the notice defect to be the reason for its return and remand to the Board of Adjustment. So on behalf of the applicant, and I was authorized to adjourn and redo the notice, which I did. I resubmitted it, and then as you recall, it took about 2 months to get back to the August meeting. And again, shortly before the August meeting, Mr. Cohn rightfully brought up a series of objections, and that led to the colloquy between Mr. Kittrick, the board members, Mr. Cohn, and myself, that we would submit briefs, which we did, and we were able to amicably resolve most, if not all, of the issues, so that the application could be a clean application, both procedurally and substantively. The notice, as you see, after the review by the board professionals, suggested that the application would be both a D variance, that would be a use variance for certain reasons, and two, that it was a C variance, it's actually a C2 variance, which would be the bulk variances. Now, in order to avoid the necessity of establishing a case under the statute and the case law for a use variance, which and I'll just place it on the record, we now have 6 sitting board members. If I was seeking a use variance approval, it would require 5 of the 6 members to approve a use application. And, but now that there are 6 members.
Hey, Mr. Stone, I apologize. I apologize for interrupting you, but I'm going to ask Mr. Mayor and Mr. Rosenberg to sign off and.
Oh, I don't see them.
Right, but I'm asking them to sign off if you would, Mr. Mayor and Mr. Rosenberg. Thank you.
Oh, okay. I'm sorry. I don't see them on my screen, right?
Yeah. All right.
So I'm just laying out the record because, again, I'm trying to make sure that in proceeding with this application, that we do it in such a way that it's best presented to the board for the board's assessment, evaluation of all of the testimony and exhibits. And as such, I am prepared to withdraw those items that might require the consideration of the board for a use variance. And they include the following. In reviewing the items that would require a use approval, use variance approval, The first thing would be, because this is, we all know this is a garage apartment. On the first floor original plan, there was proposed a bathroom. And in doing some research, I determined, and with the assistance of my professionals, that the removal of the application by removing the bathroom on the first floor, that would eliminate one of the items that would be considered for a use variance. In addition to that, there is a third level. I purposely don't call it a third floor, because our position, and I will provide testimony to this extent, the third level is not habitable. And the ordinance, your ordinance suggests that in order to have livable space on the third floor, it would have to be something where it would be habitable. We modified the architectural plans. And again, Mr. Trevino will and Mr. Murphy will testify to it with a little input from Ms. Coffin, that we've eliminated the accessibility to the third floor. And there are no stairs to the third floor. There is merely access to the third level. And that third level may contain some mechanicals, but will have no livable space. So the withdrawal of any request for livable space on the third floor, third level, I want to emphasize third level, and the removal of the bathroom on the first floor now should allow me, subject to you verifying, that I can now move the application for the C2 variance. So,
Has the board been provided with the new plans?
yes, the board, you have a plan from Mr. Trevino showing the third level. And here, I think we'll be able to bring that up on the screen so that he can describe it and be able to go over it and field any questions you might have. Al, are you there?
Yes.
Okay. You did provide those plans. Did I explain them correctly?
That is correct, actually. The only thing is on the attic level, where there is only going to be what is required by code, which is actually an access panel, 22 by 30 access panel from the ceiling, but no pull down ladder, basically just an access panel to get up to the attic, because that's requirement. But other than that, that's correct.
Okay. You will be testifying later. You're on the road. But our position, and I want to make sure I characterize it correctly, is that third level is not livable space. Is that correct?
That is correct, actually.
Okay. So, Mr. Kittrick, I wanted to clear the record so that you know that the thrust of my application is directed to the C2 variance.
Understood. I mean, I'm sure you'll have expert testimony to support that. So
I will. Okay, so the application, to that extent now, with the removal of the use variance, the bulk variances are very direct. I laid them out pretty clearly in the application, but I'd like to call, God bless you, I'd like to call as my first witness, Mr. Larry Murphy.
Mr. Murphy.
How are you? Just checking that I'm off mute.
Okay. Mr. Chairman, may I proceed?
You may.
Okay. Mr. Murphy, I want you to repeat your full name and please give us your business or occupation.
Sure. My name is Lawrence Murphy, M-U-R-P-H-Y. I'm a principal at Greenside Engineering Consulting. I graduated Rutgers University with a bachelor's degree in science. I'm a licensed professional engineer in the state of New Jersey. I've been practicing civil engineering for over 23 years and focusing on land development applications such as this one for over 21 years. And I've been qualified as an expert over 100 times at numerous boards throughout New Jersey.
Okay. I am correct. You have never appeared before either the zoning or the planning board in Bradley Beach?
I don't believe so.
Okay, I want to spread a little bit more of your qualifications on the record. can you give the board the benefit of some of the items in which you've testified? What type of cases before what type of boards and so forth?
Sure. Residential homes, pools, large subdivisions, large commercial developments, Walgreens, Walmart, Dunkin' Donuts, solar, warehouses, drive-throughs, a whole host of stuff, and a lot of testimony regarding stormwater management.
Okay.
We'll certainly accept you as qualified.
Thank you, Mr. Chairman.
Thank you.
Okay, so Larry, you're no stranger to this application. We've been working on this for many months. Am I correct?
That's right.
Okay. And at my request, first we met, we discussed the nature of the application, and you learned a couple of things. The first thing you learned is that the problem with this application is that the homeowner mistakenly built beyond his permits. Isn't that correct?
That's correct.
Okay. And at the time that we evaluated that situation, the then existing architect was Mr. Contasenti, and you and I and the applicant met with Mr. Contasenti. Am I correct?
Yes.
Right. And at that time, we reviewed all of the architectural plans and what would be necessary in order to rectify the situation. And I sent you on a task to evaluate the property, take a look at it, try to determine where the impediments were and how best to approach the application so that we can make it palatable to both the board professionals, and of course the public at large. Isn't that correct?
That's correct.
Okay. In doing that, you did visit the site several times?
I did, yes.
Right.
I
And
took pictures, visited the site, looked at the site, also reviewed the survey, multiple surveys, multiple architectural plans, provided the ordinances, and then I prepared a variance plan that was submitted to the board, and I believe is was submitted and is entitled Variance Plan, prepared by me, dated November 19, 2019.
and the board has that exhibit so they can review it simultaneously?
Yes.
Okay. So in your assessment of the area, was it necessary to take a look around the surrounding neighborhood?
I did look around the surrounding neighborhood to get a sense of the neighborhood. It's generally residential, single-family homes with Sylvan Lake to the south, and the homes generally consistent with the rest of the properties in terms of the front yard setback.
Okay. What about the front house? Did the front house have anything particular that called your attention to the roof line of the front house?
Yeah, there's solar on the existing roof. It's difficult to quantify the amount, but there definitely is solar on the roof that I was able to look at.
In our discussions with the applicant's family, we determined that they were determined to evaluate the use of renewable energy. Is that correct?
Yep.
And you know that as part of, if without being presumptuous, which Mr. Kittredge, you know, is not part of my personality, without being too presumptuous, you know that if we were able to get an approval.
Is there a laugh track in the background?
There it is.
I usually get that usually comes from the board members. That usually comes from the judge, and that's real trouble. But I don't mean to make light of it. You know that the applicant is determined to use renewable, and that would include going to solar on the back structure as well. Is that correct, Larry?
That's correct.
Okay.
Yep.
Now, but in addition to that, were you able to evaluate from your historical study whether or not any prior applications had been made and approved on this site?
My recollection is that There were several building permits submitted and obtained, and several architectural plans that were approved.
Okay, and in those earlier plans, and I don't mean on the back garage apartment building, but I'm talking about the earlier structures. Were there variances required, do you know?
I'm not sure if variances were specifically granted, but there are existing nonconformities for the existing house and the front structure and also the rear structure. And I can elaborate on what those existing nonconformities are/were if you like.
I do, but I first want to preface that colloquy with a little bit more information. As part of this application, will any of those existing nonconformities be abated, reduced, or eliminated?
Yes.
Okay, so now why don't you, as a benefit to the board, why don't you explain the nature of those nonconformities?
Okay. So the single family house up front has a front yard setback of 18.61 feet, where 25 feet is required. It's existing conditions. It's not going to change. It's generally consistent with the adjacent houses along Monmouth Avenue. The side yard setback on the house to the east is 4.87 feet, or 5 feet required. The impervious coverage for the lot is 77.5%, where 60% is allowed. The garage that existed prior to the demolition and the new construction of the house that this application is hearing, that garage that was demolished was too close to the rear yard setback and too close to the side yard setback. It was 4.77 feet off the rear yard setback, where 5 feet is required. And on the left property line, it was 2.79 feet, where 5 feet is required. The pool was also too close to the house. That was 9 feet away from not the house, but the garage, where 10 feet is required. And that, I would say, summarizes the bulk of the existing nonconformities.
Okay. Were you able to evaluate the property and the building locations by a survey?
Yes, there was a survey provided to me. There's actually 2 surveys provided. A survey of property provided by Landmark Survey and Engineering, dated May 29th, 2009, that provided me the previous garage location.
And what about and was there a subsequent survey post the placement of the garage on the rear of the property?
There was. It was done by DPCSS land surveyors with a date of August 7, 2019. And that garage, that foundation, which is currently here today, is 5.2 feet off the rear yard. So the building was demolished and that rear yard variance was eliminated. It went from 4.77 to 5.2.
So it came into
hold
on. It came into conformity on the rear yard setback, right?
It did.
Okay.
Yes.
Going. Go ahead.
The survey shows on the side yard setback, it went from 2.79 feet to 4.8 feet. So it brought it in better conformance, in my opinion. 4.8 feet. The intent was to make it 5 feet, and survey tolerances, also construction tolerances. In my opinion, it's generally conforming because you're talking about 2 inches, and you could be off by 2 inches in a survey or in construction easily with forms. So I think the intent was generally to be conforming with that structure. And it's not perceptible to see that it's 4.8 versus 5 feet.
Okay. But in any event, again, it improved what was already an existing nonconformity. Is that correct?
That's correct.
Okay. Any others that you could point out?
So the lot coverage reduced from 77.5% to 77.2%. where 60% is required.
But again, it didn't satisfy the ordinance, but it improved upon what was existing.
That's correct.
Okay. Any others?
The pool, once the garage was shifted to increase the setback to the side yard or western property line, the garage came closer to the pool. And as a result, the setback from the pool to the house, sorry, the pool to the garage went from 9 feet to 7.5 feet, where 10 feet is required.
Was that significant in your opinion?
It's not significant, and I don't believe it's visible or has an impact to the adjacent properties, because you can't see that distance from the pool to the house from adjacent properties easily. I think the side yard and rear yard setback, improving that conformance, has a more impactful, is more impactful visually to the adjacent neighbors.
Okay, so now we have to deal with the issue that the applicant first received the building permit. Is that correct?
Yes.
And then, notwithstanding not yet receiving any approvals, they made some field changes. And those field changes were the cause of a stop work order. Are you aware of that?
Yes.
Okay. And we're here today to address what the applicant believed was a de minimis field change, but clearly it was inconsistent with the original permit. Isn't that correct?
Yes.
Okay. So let's deal with those items. Let's deal with the relief that we're asking the board to consider. I want to start first with what happened to the building in regard to dormers. Can you describe that for me?
The dormers on the building.
Yeah.
So dormers.
Did that cause the building to go higher than was approved by permit?
The dormers and the roof are higher than what's permitted. The average, sorry, the building height per ordinance is 25.8 feet or 9.6 inches above ground. So each town has their own definition of building height, and some go from the finished floor to the peak, some go to the midpoint. So some of the more challenging ordinances go from either the midpoint or the peak to the average grade. So it's easy to, we'll call it, specify a compliant average grade, but for the builder, when he actually constructs it, it's very difficult to ensure that he is compliant, and it's easy to, we'll call it, error when you're dealing with an average grade calculation. So we're 9.6 inches above the grade, the peak, 9.6 inches in excess of the building height. The peak of the roof plus a portion of the dormers are above that height, not the entire dormer.
But do you, in your opinion, do you consider that a de minimis extension beyond the ordinance approved height?
I do consider it de minimis. I don't think it's perceptible from adjacent properties. I've been doing this for 23 years, and I can't tell the difference of 9 inches, 25 feet up. I need to take a measuring tool out, and you can't see the grade surrounding the properties from adjacent. So the grade of the property could actually be on average 9, 10 inches higher, and we'd be compliant, but it wouldn't be perceptible to adjacent properties that the grade's higher. So I do think it's de minimis.
Okay, for the purpose of emphasis, I want you to maybe explain that a second time in terms, not only engineering terms, which I think you've done, but in lay terms. So when you say it's not perceptible, is it not perceptible to the professional's eye, or is it not perceptible to the neighbor's eye?
It's not perceptible. It is not perceptible, I believe, to the professional eye. I can't tell that it's 9.6 inches higher either from the street, or if I were on other adjacent properties, I would not be able to tell.
Is it objectionable?
I don't believe it's objectionable.
So now what I'd like you to do to assist the board is let's go down each one of the variances that relief we're requesting and explain each one, and then let's deal with it. You know, one of the things in Bradley Beach, I think I emphasized this to you, parking is crucially important in Bradley Beach, particularly in the summer months. And since it's a shore community, if you review any of the shore community's ordinances, parking becomes an issue. And I asked you to specifically take a look at that, to determine how we were going to satisfy the requirements of the ordinance, particularly for off-street parking. You did that analysis, am I correct?
I did, yes.
Okay, so let's deal with that. What does the ordinance say in regard to off-street parking?
2 parking spaces are required for the principal structure, the single-family structure, and 2 cars are required for the garage apartment. So a total of 4 cars are required. Under RSIS, 4.3 cars are required. We'll round that up to 5 to be conservative, and 6 parking spaces or 5 parking spaces easily are provided in the driveway. So we meet the overall parking requirement without utilizing any parking in the garage.
Now, the garage ordinance says that you need 2 spaces within the garage. Is that correct?
That's correct.
Okay. So if you had 2 mini cars, they would fit in this proposed building. Isn't that correct?
It is correct. It's an unusual discussion that I don't run into often. This is a 2-car garage as a typical 20 by 20 is a typical 2-car garage. I don't believe there's many definitions or what I've seen historically in my experience that says you have to have an 18-foot wide garage so there's not a lot of clarity in my opinion on it. Practically speaking, it would be challenging to, we'll call it jockey and get those in, but I've seen pictures of 2 cars in there. It may have taken more than one maneuver, and if you have, we'll call it a 2-car garage with 2 minis, it's easy, but if you have a 2-car garage with 2 Tahoes, you can't even fit them in.
Okay, but
So
let's deal with this issue. This property is deep enough that without maneuvering the vehicles into the garage space, surely you can get 1 car in there, correct?
Absolutely.
And then because of the depth of the property, you can get at least 5, maybe 6 cars. So where 4 cars are required for the site, we can get a minimum of 6 and a maximum of 7 cars off-street parking. Is that
Yes.
fair? Is that a fair statement?
It is a fair statement.
Now, you know you're going to be tested on that. Can you defend that position?
I can.
Okay, so let's go over the rest of the variances that we're requesting. That's up to you now.
Okay. So I mentioned previously the de minimis side yard setback where we're 4.8 feet and 5 feet required. In my opinion, that's de minimis. The intent was to comply in construction tolerances or survey deviations. That would account for that, the 4.8 side yard setback where 5 is required. I think that's the minimis. The 9, the reduction of the pool setback to the garage from 9 feet to 7.5 feet where 10 feet is required. I think the increase in setback to the adjacent properties is a better use of the space than increasing the setback to the pool itself. I think the benefits of increasing that setback to the adjacent properties outweighs the detriment of reducing the pool setback to the garage structure from 9 feet to 7.5 feet. And then under existing impervious coverage, we have an existing nonconformity. We're improving that. We're going from 77.5 to 77.2. And then, as I mentioned before, the building height, we are 25.8 feet. where 25 foot's required. And we're 9.6 inches off where that's de minimis, and I don't think it's perceptible from adjacent properties. And the alternative to create or make that compliant would be either to raise the grade or to reduce the pitch of the structure or crop the top of the building to make it compliant by 9.6 inches, where I think it would create a less visually attractive appearance for the adjacent property owners and for the public traveling on Monmouth Avenue.
Okay.
Mr. Stone, I'm very sorry to interrupt you. Just to level set our discussion here, because I know there's a question as to the architectural drawings. And I know Mr. Murphy's not testifying on the architectural drawings, but you offered in the beginning of your statement that the first floor bathroom would be removed. I'm looking at the posted architectural drawings dated July 16th, 2020, that's on the website, and we're not seeing that removed. I want to make sure, for the benefit of the audience and everybody, that we're all looking at the same thing.
Let me say this. The plans as proposed included the bathroom. I'm representing to you and to the board that if there is an approval, we will agree to, as a condition of the approval, removal of the first floor bathroom.
But we have no drawings to
No, we're just going to excerpt that from the plans. I mean, I can.
Okay. All right, we'll carry on with the testimony. I'm sorry, I just wanted to make sure everyone was on the same page here. So again, we're looking at something that we're provided drawings that are different from what your original statement was.
Okay. No. The plans are different from what I said. That's true, but the distinction is this, Mr. Chairman. If we were moving an application, and on the plans that you're looking at, there was no bathroom, and I said to the board, we propose a bathroom, then ordinarily the board would say to me, we want to see the plans the way you describe them. But when you're removing something, it's creating a less intense use. And I respectfully would suggest that if the application is approved and we make a representation that we are removing the bathroom, then you can do that subject to your board professional's approval that that's what we're doing. I don't think you have to look at a plan where I'm telling you I'm removing the bathroom.
Mr. Stone, based upon, and this is my own personal view, based upon what the applicant is asking and the deviation that has occurred in this entire process, I would think that it would have been more helpful to have provided a plan for what it would look like in end state. And I'll let Mr. Murphy carry on with his testimony. And I'm sorry, Mr. Murphy, for interrupting you, but I have to say, I was confused, and I thought some others might be confused also. So Mr. Murphy, the floor is yours.
Thank you.
Mr. Chairman, I'm going to return to that, your comment, your inquiry later on in the
Sure.
All right. But Mr. Murphy, I want you received a report from the board engineer, am I correct?
Yes.
Okay. Were you able to review it? I think it's dated, is that the report that stated?
August 12th, 2020?
Yep. You have that report in front of you?
I do.
Okay. Now, what I'd like you to do now, there were a series of comments made by the board professionals. I believe that report is signed both by the engineer and the planner. Am I correct?
I'm looking. Yes.
Okay. So, of course, I don't want you to comment in regard to the planning comments. Are you able to review the report and comment on, some of it may be duplicitous, but comment upon anything raised by the engineer?
Yeah, so I'll start with number 1, that's factual. 2 is factual, and then there's just a modification to 2C, which just describes what variances are required. Same with number 3. I'm not sure if I should touch on those. Let me see if I can find. I think B1 is in regards to the minimum front yard setback, which I provided testimony on. 2, which is the minimum side yard setback, which I provided testimony on. And then impervious coverage, number 3, I provided testimony regarding. 4 is the minimum side yard setback, which I provided testimony on. And then we did provide testimony regarding letter C, which is the parking. And then D, which is in reference to driveways and parking areas installed shall have a minimum of 8 feet in width and shall be located 3 foot from a side property line. I believe there's an existing nonconformity. No modification to the driveway is proposed, except as it approaches the garage, where further, I don't think any modification to the garage, the driveway is proposed, and that's existing conditions. And then 4, I think, is all proofs for the planner. 4.5, we can add the note in number A, add the note in number B. C is stipulation that taxes are currently paid. And the applicant, D is the applicant shall secure any and all construction permits needed for the project.
One more thing, since Mr. Fuso has asked about the bathroom, you know that we have stipulated that we're going to remove the first floor bathroom. Isn't that correct?
That's correct. And looking at the plan, once you remove the bathroom, it'll be much easier to fit 2 cars in without as many maneuvers. 1 car would pull all the way forward to the rear left of the structure where this existing storage area is and powder room is, and the second car would pull in and then pull off to the right. You would still have to pull the last car out before you pull the first car you pulled in. So I think that will improve the conditions and maneuverability within the garage, within the structure of 2 cars.
You know, in handling these applications, is it unusual from time to time when presenting an application, when there is a change, like something removed from a plan, that becomes a condition of an approval?
It's very common.
Okay. I don't want to get into a disagreement with Mr. Fuso just yet, but I know historically that is done. Am I right? Do you have anything else to add to the application, Mr. Murphy?
I don't.
No. Mr. Chairman, we are prepared to have Mr. Murphy field any questions. And of course, if Mr. Cohen or someone wants to examine him, we're prepared for that as well.
Sure. Questions of the board? Anyone? All right, Mr. Murphy. So essentially, what your testimony is that on the side yard setback and on the height, those changes are de minimis. Seems to me my back of the envelope calculation, 4% on the height and 2 inches on the left side setback.
2.5 inches on the left side setback. Yeah.
Okay. And that would be de minimis. Okay. And then as far as the front yard and the existing nonconformities, they are what they are. You've improved
Yes.
You've improved the site plan. So it appears that the footprint of the building was built in good faith with attempting to adhere to the zoning rules and dealing with the site as it's seen. Would that be correct?
It would be correct. I've built my own garage and had a form move 3 inches on me.
Okay. That's all I have. Members of the public, questions for Mr. Murphy.
Mr. Cohen has his hand up.
Mr. Cohen, you have been sworn.
So, Mr.
Thank
Chairman,
you.
if I may, at this time, before the public asks questions, Mr. Cohen have the opportunity to do cross-examination.
Sure.
Thank you, Mr. Kittrick. I appreciate your time here, Mr. Murphy. Mr. Murphy, you said that the impervious coverage reduction was 77.5 down to 77.2. That would really be de minimis, would it not?
It's a small amount. Yeah, it's not significant.
Okay, is
Yep.
is 60% to 77.2 de minimis?
No, it's a fair amount, but
Great.
it's not unheard of on existing residential sites where it's been built 30, 40 years ago, 50 years ago. We see this a lot.
Now, when you did your research into the permits, did you use the town SDL portal at all?
I did not. I was provided the architectural plans and documents by Mr. Stone.
You didn't do the research yourself?
I did not.
Okay. The spacing between the garage and the pool at 10 feet, would that be done by the ordinance for safety?
I'm not sure what the intent behind it by the, we'll call it the people, the town council and the planning board that drafted that ordinance. It could be for safety or it could be for construction and not undermining the pool foundation or a garage foundation.
Many ordinances are done for health and safety purposes, are they not?
Some are to prevent jumping from the building into the pool from either elevated decks or elevated roofs. Looking at the structure, there's not a lot of places to climb up. There's no balconies or decks which would allow a person to jump and land in the pool, if that's the question.
I'm looking at the safety factor, sir. When you did the research, did you see the approved plans dated September 13th, 2018, which I would like to enter into the record? I submitted them on June 18th. They were listed as my Exhibit 2.
So what's the date again, just so I can look it up?
The plans are dated September 13th, 2018.
And you're looking at architectural plans?
Yes, these are architectural plans I submitted to the secretary for the June 18th meeting.
All right. So I have three sets of, multiple sets of plans. What's the revision entitled?
This is the approved, it's got a stamp on it from the zoning office, dated September 13th, 2018, 306 Monmouth Avenue. I entered it, like I said, it's on the June 18th documents.
All right, let me see. I'll see if I can find that, but what's the question?
Oh, the question is, have you seen it? That's the first question.
I don't have all of the architectural plans in front of me. I reviewed multiple sets of architectural plans.
But you never viewed the approved plans?
No, I may have reviewed those. I don't have those dates of the plans in front of me without taking a fair amount of time to track back.
If Ms. Dicker could post it, that would be great so the public could see it.
Trying to locate it now.
Thank
You
you.
have the ability to share too. Do you have it on your screen?
No, I do not. I don't have them electronically. I have all paper copies here.
Yeah, they're on the Borough website.
which item number?
It was Exhibit 2 on my exhibit list that I submitted. 306 approved plans is the title.
While we're looking for these, can I ask a question? I was just wondering if we're not counting the attic space as living space, would that decrease the total amount of living space that we were concerned about? The 60 to the 77, would that make a difference in that? Yeah, the impervious.
If I could, that's negligible because that's measured in plan view. So when one story is over top of a second story, it's the same area.
Okay.
So it doesn't help.
Okay, thank you.
You're welcome.
Mr. Cohen, please proceed.
Yes, sir. Well, I had a number of questions related to that, but I can continue with Mr. Murphy. Oh, there you go. Oh, that's exactly the document. Thank you, Ms. Dicker.
What specifically are we looking for?
Yeah, we're looking at just the overview of the building. The front elevation is fine. If we can pull that up. Had you seen these plans before?
I have. I remember seeing one with a stamp on it.
No, actually, this is not the one. This is not it. It's a different.
This is not it.
Yeah, the first picture you put up was what I was looking for. The first, yeah, go over to the right. That'd be great. It should be right there, right behind where our faces are now. Yes.
Yeah.
we can't get that, right?
No.
Oh my God.
I just moved you. Yeah, because it's on my screen. Can you?
No.
Mr.
No,
Cohen, if you could change your view, I think you might be able to see it because we.
Okay, as long as you're seeing it, I have it in front of me, so I'm just concerned about everyone seeing it. Mr. Murphy, have you seen these plans before?
Can you scroll to the
yes,
to the
that's
title
perfect.
block?
Down, up.
Can you scroll down to the title block, please?
Sure.
Yes, I have.
Okay, great.
I found them.
Now, the way the roof pitch is there, would it be possible to put solar panels on there?
Yes.
Okay, great. And that's an approved building. You're aware of that, correct?
Those are the, I have them marked as the approved plans.
Great, okay. And I'll continue along. So the dormers that we're talking about granting variances for were not on this original plan, correct?
That's correct.
Okay, how does that happen? How does that happen? Did the architect draw different plans between approval and now?
I wasn't there during the exchange between the architect and the applicant or homeowner and the contractor. Sometimes you make field changes are made in the field, and sometimes people believe they're not of significance, and sometimes they're wrong, and sometimes they are significant. So a lot of things have to change in the field because of conditions.
So builders don't pre-shoot it? They don't make a mark on a telephone pole and say, okay, there's my elevation where I need to be?
Some do, some don't. It depends on the quality of the contractor, depends on how comfortable they are. So it varies from contractor to contractor.
Okay, and now are these, what is the space that has no garage door going to be used for?
So that is what's on the building or inside the building?
Well, in the plan that the plan that's been submitted as your new plan, There's only one garage door, correct?
There is only one garage door, correct?
So what's going to take place in that space where there is not the second garage door?
So I would anticipate, like most people, including myself, that the entirety of the garage will be used for storage and not for parking vehicles, but that's generally how people use the garages. So I would anticipate, if we're lucky, one car is going to be parked in it and the rest of it's going to be used for storage of whatever different things that people store.
And the plans should be revised to show what it's going to be used for and stated, should they not?
It can be. It's not a defined space. It's an open area that you can either use for storage or parking. You don't want, obviously we've stipulated to not having a bathroom, so it would be open garage with no structure, no walls.
Would it operate better if there was a garage door to park in there?
Would it operate better if there was a second garage door?
Yeah.
It depends on the intended use. If the intended use is for storage, no. If the intended use is to park a second car, yes. But there's something to be said about having a man door in the to a garage. So if you've ever had an experience where there's been a power outage and your garage door opener is electric and there's no man door, you can't get in. So having a man door makes it more practical, in my opinion, to the structure.
But we also have another door on the east side of the building. So we already have another form of access, don't we?
It's depending on what type of door that is, whether it's a sliding glass door. Generally, those aren't utilized and they're difficult to lock and unlock from the outside.
Then why do they make them if they're so difficult?
That is a question that's above and beyond me. They make them and they're available and people put them in for a variety of reasons, to be able to see out, to be able to have a wide opening.
Would the 2 spaces and 2 garage doors required in the ordinance prevent the conversion of that space to living space?
No.
Oh, it wouldn't?
No, you can, I've seen people convert, you can use that space however you want with 1 or 2 garage doors.
So would a man door even make it easier to convert that to living space?
I think that's somewhat too subjective for me to answer. Yes or no, it depends on how you're laying it out, what you're doing. There's so many different variables that go into that.
But it can be done, correct?
Anything can be done. You could eliminate, both garage doors. You could put in, 3-man doors.
Mr. Murphy, I'd like to get to the crux of something here, the height. Now, I've heard your numbers, and I've wondered if you did review the revised plans that were submitted as one of the exhibits from your client. I believe they were done by a Mr. Travasano, is that it? Those are
yes.
posted that include. Have you reviewed those plans?
I did, yes.
Okay, great. Then I'm a little, did you review them for the height?
Yes.
You did. And what's the height reflected on those plans?
So are you talking about the height reflected shown on the drawing or the ordinance definition of building height?
The height that's reflected on the plan.
It is 26 feet, 3.5 inches.
Okay, then if that, and that's from the slab, correct?
That is from the slab, yes.
So that's not from the average grade, it's from the slab.
Correct.
Okay, and then how do you get your 25.8 number then? If it's...
So the building height definition in the ordinance says the vertical distance measured from the average finished grade surrounding the building to the highest point of the roof. That's the definition. So you take multiple shots around the perimeter of the building and you average that existing grade. And that's how you calculate the height. So you take it from the peak of the roof, which is, we'll call it 26 feet, 3.5 inches above the slab. And then you bring it down to the average grade. That's a calculation.
So is the grade back pitched into the slab?
So the back of because the land naturally slopes from the front of the property and goes up to the back of the building is buried. The back of the garage structure is buried. So those grades are higher in the back.
Oh, okay. So that means that the building is actually higher visually for the neighbors then, is it not?
In comparison.
In comparison,
to what?
If it wasn't graded up so high.
If it wasn't graded, you're talking about the grade surrounding the property or surrounding the building?
You're using the average grade, but you're saying the average grade is actually higher than the slab level.
I'm using the I'm using the township, the borough ordinance to make that calculation.
Okay.
So as I said during my testimony, it's generally complicated and varies from town to town depending on their definition. Some take it from the midpoint, some take it from the peak, some take it from the average grade, some take it 5 feet outside the building. So each town has a different ordinance related to building height.
Great. So this structure is substantially higher than 25 feet, is it not?
I have to object to that. That's not what he testified to.
Okay.
He testified he's following the borough's ordinance.
Perfect. I'll take that one up with the, now, let me ask you about how the foundation location plan was done. Do you know when the stop work order was issued?
I do not have that in front of me.
Okay.
Do you have it? Can you
Yes, I
provide
do.
that date?
That was issued by the Borough of Avon, and I've included that. I'd like to enter that onto the record.
So ordered.
That is Exhibit 8 on my list from June 18th.
Christie, do you have that? You can mark that, please.
Be reminded about.
I would, so I'd like to enter that onto the record. Then I would also like to include the foundation plan that was submitted by the applicant as drawn by DPCSS.
I've added it to reminders.
Christie, if you could mark that also and enter it into the record, please.
So I don't see the.
Mine would be the Exhibit 8, stop work order for 306.
Okay, so Exhibit 8 is the stop work order.
Yes, and that was from the June 18th meeting.
Okay, yep,
Thank you very much.
got that.
And then now, when you build something, Mr. Murphy, is it normal practice to do a foundation location survey before you frame the building and use lumber and man hours?
It varies. Sometimes you stake the property line and then you offset from the property line. Sometimes you do stake out the corners of the building. So that part of the challenge with staking out any building is you can't actually stake it where the corners are because you have to excavate to build the foundation. So you have to do offsets. So you need 3, 5, 10-foot offsets. Normally I think they're 10 and 20-foot offsets. We obviously don't have that room because we'd be on other people's property. So it makes it a little challenging to actually stake this out because any excavation would disturb, we'll call it 3 of the 4 stakes.
Do you ever set the pins in the hole?
No, because think about it. The surveyor comes out, they set the pins, the contractor comes in, digs the excavation. You can't set the pins.
I'm talking about setting the pins after the excavation is complete in the hole.
Based on my experience, no. You stake the corners with offsets, you do the excavation, and then the corners are still present to check, and then you actually build the forms and pour the foundation.
So this foundation location survey, which reflects the nonconformity to the west side of the building, is dated August 7th of 2019, which is 6 days after the stop work order was done. So they didn't give it much thought, did they?
I object to that comment.
Yeah, that's, he has,
I'll withdraw that comment, but the impervious coverage, when you
and
said
by the way, this isn't the time for comment. This is the time for
Yes.
question.
I'll withdraw that question.
Well, it was a comment. That's the point. There's no comment, there's questions.
Yes. Do you have did you draw a grading plan for this property to establish the height? Is there a grading plan? Because I didn't see one submitted, Mr. Murphy.
So DPCSS land surveyors did a survey, and they have shots around the corners of the building for the garage.
But would a grading plan be the proper way for the town engineer to do the review to establish what exactly is the height?
So a grading plan is a proposed plan, and we have existing conditions, and that's why you do an as-built, which is what was done, a garage foundation location plan prepared by DPCSS land surveyors dated August 7th, 2019, which has grade or topographic elevations around the property, around the garage foundation. There's 12 shots.
Mm-hmm. To establish the grade, you have to go all the way around and run the average grade. Wouldn't it be easier to do that in a grading plan and know that we're being exact for the residents of Bradley Beach?
So I think we're confusing two terms. A grading plan is generally proposed where I'm proposing to modify the topographic conditions, and that's not the case here. We're doing an as-built, and a surveyor needs to obtain that topographic information, which is what was provided, I believe, to the town with the DPCSS land surveyors. So I think there's sufficient information for myself, and I believe the municipality to make that assessment.
Okay, great. Thanks. No further questions. Thank you, Mr. Murphy.
Thank you, Mr. Cohen. Members of the public, questions for Mr. Murphy?
Brigitte has her hand up.
Brigitte, please proceed.
So anyone who's going to ask a question, when you, before you ask the question, just state your name and your address, please, okay?
Can you hear me? Yes, we can hear you. Can you hear me now? Yes. Do I have to swear in or anything?
I can't hear her.
I'm sorry, Brigitte, we can't hear you. Brigitte, we'll come back to you if there are any others with questions.
George Januzzi.
Mr. Januzzi.
Yes, hi, thank you. George
Where is
Januzzi,
this
608 Evergreen Ave.
You want me to see you?
I'm sorry, I didn't hear. What was the address, Mr. Januzzi?
608 Evergreen Avenue.
Thank you.
Thank you. I can go ahead?
Yes.
Okay. Sure. Mr. Murphy, question for you. When you spoke about parking two vehicles in the garage, you mentioned that to fit two cars, some jockeying would be required. So, my question is that, would it be a safer option if you were to park two cars in the garage, whether you decide to do that today or 3 years from now? Would it be safer to have two full-size garage doors?
Safer for the residents?
For someone who's maybe standing in that garage when the car is being pulled in, the person parking the car, structural damage risk, pulling two cars straight into a garage versus what you quote said jockeying into the garage.
Okay. Is it safer? Is it safer to have two? Well, I'm gonna modify my answer. Is it easier to park directly in with two garage doors or one, we'll call it wider one? It is easier to park with one wider one. Two separate ones I actually don't like because there's so many times I'm called to do an inspection of the center column and that people hit it because it's not one car, one garage, or one larger one. So I would say it's easier. It's not necessarily safer because the speed of the vehicle is so slow that it generally does not pose a risk to pedestrians or the structure.
But one larger door, meaning greater than one, I think, 8-foot door, would be certainly easier, I would imagine. Is that your view?
It would be easier to get in with one larger garage door than one smaller one, yes.
Okay, thank you. And a question for you regarding the original plans that Mr. Cohen introduced that you said you reviewed from September of 2018. So comparing those plans to the current structure as built or the revised plans that have been submitted, getting from that design with respect to just the garage doors, let's say, from going from 2 standard garage doors to 1 standard door and I think you called it a man door. Going from A to B in that case, how would you qualify that change? So I've heard a few different terms used, so I'm curious, in your opinion, would that be a de minimis change, a field change, or, to use Mr. Stone's words, a mistakenly built beyond permits change?
Are you talking from a building permit standpoint or a zoning perspective?
Any you'd like
Those
to
are
give.
2 separate things. Sorry, what?
Any or both you'd like to give.
So the zoning issue, I think, is a subtle issue that many would miss. And I think you would have to specifically know the ordinance back and front as a contractor, as a homeowner, and know you're violating that, and you're not providing 2 cars in the garage, you're only providing 1. And I don't think that would qualify, in my opinion, as something that would hit the radar of either a contractor or homeowner, that I'm going from 2 garage doors to 1. Because I still have 2 cars in the garage. Technically, we do need a variance because we, are only providing 1 garage door. But I think it's subtle, and I still struggle with that. That generally I see a 20 by 30 foot structure. It's a 2-car garage. I can fit 2 cars in there, and we're talking very technically now. How do you get them in? Does that require a variance? So I would say, from a zoning perspective, I would say that's an easy mistake to make in that change. From a building perspective, you're going to be changing the beam, you're going to be changing the column. You should have submitted that to the building department for a change, or at least mentioned it to the building department and had them say, it's okay, you can go ahead. So that should have been submitted for a building modification to eliminate the 2-car garage to the 1-car garage.
Okay, thank you.
Brigitte, are you back?
I was going to say, I have a Thomas McGuire. I'm assuming that's Brigitte.
That's me. Can you hear me?
Yes.
Yes, Mr.
Okay.
Brigitte.
Brigitte McGuire. Do I have to introduce myself? 610 Brindley Ave.
Okay, thank you.
You're good.
Thanks. So how does it happen to mistakenly build beyond permit plans? Because doesn't the builder have to follow the plans that are like put on the property the entire time?
Is that question directed to me? Larry
Sure.
Murphy, the engineer? Okay. So it depends on the contractor and the quality of the contractor. Some builders will look at the plan and say, I know what I'm doing, I don't need the plan. An architect shouldn't tell me what to do. And other contractors follow it to the T. It really varies based on the contractor. It happens more often than you think. And
but for a whole third level? Like a level?
So I wasn't there during the conversations and privy to the whole discussion and how it played out, but it does happen. It can happen. I'm not saying it happens all the time, but it does happen.
So this was this a build? The owners lived on the property while this construction happened, correct?
Yes, I believe that's the case.
Okay, so they watched a whole third level get put on mistakenly? That's what I'm wondering. How does that get overlooked?
I think it's an unfair characterization to say that there was a third level. I think what's there we'll call it above the third floor plate is an attic. So the average person, we'll call it the average, layman, doesn't really understand the complexities of building permits, building requirements, zoning ordinances. So it's very challenging for the average person that is not in the construction field, in a building department, or on a planning board or zoning board to understand these very distinct differences. If I talk to my wife about it, she has no understanding and no idea.
Okay, so, but isn't that why you hire a builder and submit it to the town so that it's all done by the ordinance?
Yes.
Okay. So I have a few questions. Would I be able to just add a third attic or an attic to my accessory structure without submitting any plans to the town?
That's a complicated question because I don't know your existing structure. Are you talking about putting a third floor plate plus an attic, or are you talking about
I think we're getting into hypotheticals. Let's stick to the application that's before us, okay?
Okay. So being that this was mistakenly done, we just have to trust that attic steps aren't going to get put in after the fact, or a living space in the garage. And if mechanicals are in the attic space, then he could be added up there as well. Is that right?
So I think that's the case with anybody's home, anybody's construction. You can make changes after the building inspectors issued an approval, and that you could do that, I could do that, and you risk getting caught and being fined. And that's what the building department's there for, is to issue basically stop work orders, non-compliance, and there's fines associated with it. So,
okay,
but that's not the intent. That's not the intent here. When you have an attic space and it's as high as it is and as small as it is with mechanical space, it's not usable.
Could you stand up in the highest part of it?
It's, I believe the highest part is 7 feet at the peak. And once you have collar ties in it, it's going to be below your head.
Okay, so you can stand in the peak of it, in the highest part.
And
average
walk?
person.
No, you can't stand up and walk. You can stand up and poke your head between the collar ties and be between the rafters, but you can't walk because you'll bump into a collar tie.
Okay, but it could be used then as like a loft with a mattress, like a bed loft?
There's no attic stairs, and then there's a mechanical HVAC unit that's going to be on the floor with supplying heat to the downstairs. I would say it's going to be very challenging to use that for anything, given the size of it.
Could the, I asked this because I was asked this actually when I was in front of the board. Is it possible that the owners would chop the roof off to lower it to the appropriate size?
Is it possible that the owners can chop the roof down?
Yeah.
It is possible to cut the roof down. You could go with a lower pitch just at the top to remove the 9 inches and do we'll call it a metal roof. But I think it would be less attractive than what's there, in my opinion.
Okay. And my last question is, bathrooms are allowed in the common area, I believe, on the first floor, correct?
My understanding is based on this review of the ordinance and discussion with the, during the course of this, that a bathroom is not allowed.
Okay, I'm pretty
On the
sure
first
bathrooms
floor.
are
On the first floor.
allowed, like in the garage area. I'm pretty sure bathroom is allowed in the common area. And my question to that was, so if that's removed, then that's not really gaining anything as far as, like you're not giving up anything, is that correct? But if you think it's not allowed, then that's a hard question to answer.
I think it's not allowed, and we've stipulated that we are removing it. And that's creating more space for vehicles to park in the garage, or for the owner to use it for storage like most homeowners do use it for.
Okay, so is it implied that a 2-car garage is supposed to have 2 garage doors?
So there are many garages that have one door, but it's a 12-foot wide door, a 14-foot, a 16-foot. So there's many 2-car garages with one door. It's just wider than an 8-foot door.
Meaning it's one of the single double wide ones?
Yes.
So is that what's getting put on, is one of the large double garage doors, but it's one door?
No, what's being put on is one door, and I believe that is, I don't have the exact width, but it's not 16 feet wide.
Oh, okay. Okay, thank you very much.
We have
Additional questions?
Kim Januzzi.
Ms. Januzzi.
Hi, Kim Januzzi, 608 Evergreen Avenue. Just a couple of questions. So with respect to the bathroom, I just want to clarify, is the bathroom already built and it's going to be taken out? Or when they say it's going to be removed, it's going to be removed from the plans?
So it's partially constructed, not fully constructed. It's studs with some plumbing, and that will be removed.
Okay. And when that's removed, there's nothing preventing having either a double wide single door or 2 garage doors, 2 individual garage doors.
So there's nothing preventing it. There is something preventing it in terms of existing conditions. What was constructed, a foundation wall was built, or a stem wall was built between the existing garage opening and the man door.
Okay, and that was a decision that was made by the homeowner when they drafted the plans with the architect, or was that something that was required by the building, or that was something they chose to do?
I think that was something that they chose to, that was done, and it wasn't required by the town.
Okay. Oh, it was required by the town?
Wasn't required by the town, sorry.
Was not required by the town. Okay. And then just the other clarifying question, with respect to the changes that were made and the discussion about field changes, and sometimes things happen with the builder, is it the case for this particular example that the builder made these changes without approval from the homeowner? Or I'm just trying to understand exactly what happened, how these changes came about, and who was involved and who approved them.
So I wasn't at those meetings or at that privy to those discussions, so would be uncomfortable specifically stating who did what and what was said.
Okay, thank you.
Mr. Cohen?
Thank you, Mr. Chairman. I have a couple questions, Mr. Murphy, based on these questions the other folks asked. So if this happens all the time for contractors, as you said, and you're adding dormers and another attic, wouldn't the materials list be different?
Would the materials list at the beginning of the project be different?
Yeah.
If the change was made at the beginning, but if you make it, well, if you make it in the middle, then the material list is added at that point. So during construction, you would order some of your materials, and as you're building the job, you then order more and then more and more. And if a change happens, you then order different material. So
if you're overbuilding the job, you'd have to buy more material, correct?
I'm not sure if I understand your question.
Well, if you had a materials list that you bid when you bid the job, and now you need more materials because you're changing the scope, you would have to buy more materials, wouldn't you?
So some contractors, and I would say few contractors, I would say specify every single piece of material they need at the beginning of the job. I think that's a rare contractor that knows how many nails he's going to use, how many shingles he's going to use before he bids a job and before he orders. He's going to order, do the foundation, order lumber, and then if he runs short because he had somebody that wasn't that good cutting too much material, you'd order more. So I don't know if I'm not sure where we're going with that question.
I just wanted to clarify that it would take more material to build the as-built plans that are here than it would take to build the approved plans. Is that correct?
Yes, it would.
Okay, great.
Mr. Cohen, can I just follow up? I'm sorry to interrupt you, but Mr. Murphy, you've piqued my interest. What you're saying is, all right, you run out of 2x4s, go get a few more. The dormer windows, would you just have them laying around on site to make a change? Okay.
No,
so
you specifically have to order.
You would specifically order.
Yep.
And what would be the course of events that would happen?
There was a discussion that happened
between what parties?
What?
Between what parties?
Probably between the owner and the builder. It depends on it depends on the involvement of the owner. Some owners are not as involved. Some are just, hey, that sounds great, here's the check, and others are super involved. So it's a very specific question to the relationship between an owner and a contractor, which I wasn't privy to. And I'm talking in generalities.
Mr. Cohen, I apologize for interruption.
No, I thank you, Mr. Chairman. Mr. Murphy, what is the current state of this building?
The last time I visited it, there is Tyvek on there's sheathing Tyvek, it's studs with roofing material on it, and the inside's not finished.
So the dormers can be removed and the height can be lowered, can it not?
It can.
Great. And then
actually it can't.
Wait, who's that?
This is hi, this is
and there's no testimony from anyone but Mr. Murphy. So mute.
May I ask who that
You need
was?
to be muted.
What?
So I think the clarification may be, that wasn't me agreeing to remove it. That was answering a question, is it possible?
As an engineer, it is possible, is it not?
It is possible.
Is it less intrusive to do it now or when it's a finished structure?
I think it's substantially finished at this point.
But that,
in terms of the roof line.
But does it have insulation?
I don't remember whether it has insulation or not in the attic.
Does it have sheetrock?
It does not have sheetrock. You wouldn't be putting sheetrock in the attic anyway because it's an unfinished attic.
Oh, so it's easier to take it down now, right?
No, because you're not putting any finished sheetrock in after you're done because it's an unfinished attic today and in the future.
So but your point is the dormers can be removed and the height can be lowered, correct? That's what you testified.
Yes.
I think he already answered the question.
Yes, he did. I'm fine with that.
You're repeating yourself.
I
So
have a
let's-
question about the loft area. At the previous submission, the loft area was habitable, but now magically it's not habitable. How does that happen?
So are you talking about on a previous set of plans?
Yes.
So I'm going to leave that to the architect, but it comes to building code, lack of collar ties, and he can specifically discuss the building definition of habitable.
Great. And then,
in my opinion, it wasn't habitable.
Okay.
It wasn't habitable previously.
Now, based on your testimony about contractors, should this board expect to get a lot more applications?
Hold on, I have to interrupt now. First of all, Mr. Cohn has had an ample opportunity to ask a full line of examination and cross-examination. And he's reaching into the area of unnecessary hypotheticals, becoming argumentative, unnecessarily argumentative, and he's hypothecating where it's not fair. There's no secret that this property was built. It was built over permit, and it's the reason we're now before the board. So to ask these questions as to what can happen, that's not the relief we're seeking.
If I may, Mr. Kittrick, these are follow-up questions to the testimony by the professional after question by other residents.
So here's what we're going to do. First of all, when I'm done saying what I'm about to say, I'm going to ask you to repeat the question because I don't even remember what your question was. But we have to have a little bit more tighter order with this. So for the next witnesses, this is how the procedure is going to work. You get to ask, so there is direct testimony. The board asks the questions. Mr. Cohn, you get to make cross-examinations, questions, and the public gets to ask questions. You do not get to ask whatever questions you want again. You only, in fact, Mr. Stone should have the ability, if he wants, to ask a redirect question, and you would only get the opportunity to follow up on questions that were asked on the redirect. So you're really taking a lot of liberties here, getting a second bite of the apple, covering questions you neglected to cover before, and that's really not how it works. So,
Mr. Kittrick, I respectfully disagree with that. The questions that I asked in the follow-up were generated by the public. And if that's the case, I would be happy to let the public ask all their questions first, and I will go last, sir.
Well, you can disagree, and I accept that, but that's not the procedure, and that's not how it works. So, and you don't get to select the procedure. So,
may I comment upon that too?
When I'm done, you can. So, for the next witnesses, how it's going to happen is, for Mr. Stone's witnesses, he'll ask his witnesses question. The board will then be allowed to ask questions. You'll have ample opportunity to ask your questions. The public can then ask questions. If Mr. Stone decides he wants to follow up and ask some redirect questions, he has the opportunity to do so. And then your follow-up is limited to what was asked on redirect. That's the limitation. Otherwise, it's a never-ending question, and I don't think that's the purpose of
The
testimony.
chair is in concurrence with Mr. Kittrick.
Yeah. So what was your question before your last question? I don't even remember what it was.
My question was, based upon Mr. Murphy's testimony about contractors, should this board expect to have a lot more applications?
And I object to that. That's irrelevant.
Yeah, I don't think that's a relevant question.
Okay.
Yeah. Anything else?
Yes,
Mr.
I've had
Stone?
a,
Well, hang on, Mr. Stone, did you have something you wanted to add?
No, I think what I was going to say, Mr. Chairman, is that Mr. Kittrick laid out the proper procedure. Mr. Cohn is acting in the capacity of an attorney. And that was both in the prior meetings as well as the phone conference we had with Mr. Kittrick this week. And in order to have an orderly manner of questionings, there's direct testimony, which I provide, then there's cross-examination, and then I opt to have a redirect. But Mr. Cohn, in the capacity of a lawyer, he can't continue after all of the other questions to continue a cross-examination. That's not fair. He's not a member of the public now. He's acting in the capacity as a lawyer. So
That's fine, Mr. Stone, and we will continue the meeting as laid out by Mr. Kittrick. Do we have any other questions from the public?
yes, we do. Mr. Jankowicz?
Yes, my name is Joe Jenkowitz, 507 4th Avenue. My question is regarding to the parking. Whether it's one garage or two garages, can you do a K-turn to get out of the garage and then drive out of the driveway head first? Or do you have to back out all the way on your own in reverse?
I heard the question. So your question is, can you do a K-turn and then leave the site?
Yes.
So it's very similar to existing conditions. There's no change of what's going on. Generally, you would back out of the previous garage or this garage all the way. There is a chance you can make a K-turn with a smaller car. It's probably not a comfortable maneuver under existing conditions prior to the demolition or currently for most people to do. Most people are more comfortable backing straight out than making that K-turn.
That's very interesting because when I built my backyard garage apartment, I was required to have enough space to do a K-turn to get out. But that's not a question, that's just a statement, so I'll continue with my question. You mentioned that you could fit 5 parking spaces in the driveway. So if I have to back my car out of the garage, are the 5 people that are in the driveway ready to back out of the driveway in order to release me from the garage? And how does that work?
So generally what happens in a configuration like this, where you have a single wide driveway, and let's say you have 3 cars or 4 cars or 5 cars, they're generally all related family members. You would take the last car and you would utilize that car. That's what the majority of people do. If it's 2 cars, you may back 1 car out and then take the car in front. So it's a personal preference on how it's done. Some people take the last car. Some people will move the second car. It's rare that you're going to move the 5th car that's in the garage.
So,
assuming there's 5 cars on any particular residential lot, which is unusual.
But the ordinance says you have to have 2 and 2, and it doesn't seem to me like you have availability to have 2 and 2 in this scenario.
We do have availability. We have availability for 5 cars in the driveway, 1 car in the 1 car in the garage pulling straight in, and then a 7th car being maneuvered in.
I would like to watch that. Okay, thank you.
Let's keep our comments to the comment period, folks. We're running late already. Next question.
I don't see any hands up, but I have a lot of people muted that are not participating via video. So if you have a question, please unmute yourself.
No. Okay. If you want to.
I don't
Okay.
see any, yeah. I have to scroll across 3 pages, so just give me a minute.
Take your time.
Okay, no, I think we're good.
Comments
Mr.
from-
Chair.
Mr.
Chair,
Frieda.
this is Jerry. Yes. I would just like to, at this time, confirm with the applicant's engineer and lawyer that they do agree with the variances that we note in our letter, and that they are agreeable to obtaining those, recognize that they're variances that the board needs to grant.
Yes.
Mr. Stone?
Well, I defer to Mr. Murphy, but I'm assuming that that does not include the use variances.
That's correct. This is just the bulk variances.
Yes, and I would agree. Mr. Murphy and I would agree to that.
Very good, thank you.
Anything else from the professionals? Comments from the board?
Mr. Chairman, can you ask whether or not we can take a 5-minute break?
Certainly. I'm going to reserve my comment after the 5-minute break. We'll certainly take a 5-minute break, reconvene. Please mute your phones. Thank you. Hearing plans go, that you take this to heart. My fellow board members may be of different mind than I, but this is where I stand on this issue.
Can I make
the footprint of it?
Mr. Chairman?
Does not seem to be a problem. Yes, Mr. Stone.
Couple of things. Number one, I think your suggestion is fair and reasonable. I do. I think it's fair. And I understand why you're doing it. I'm going to suggest to my client that whatever plumbing is in that first floor garage area be removed. I'm going to tell them so that you're satisfied that they're going to continue with their good faith effort. Number one. Number two, I'm going to ask for permission. The building, we were hoping to be before the board months ago. Now, we were there in June. We're now approaching the winter months. In order to seal the building, they may have to cover some of the outside siding. So in conjunction with the removal of whatever plumbing is there, and I don't mind if the engineer or the building inspector wants to check it out after it's done before the next meeting, but I'd like to also get the board's approval to at least seal the building so there's no damage from animals or weather until we can finalize the application.
Yeah, the board doesn't not have the authority to give that approval.
No, can we check with the building inspector to see if he'll allow us to do that?
Of course you can, but we don't control that.
Okay, but I'm going to suggest to the client to remove whatever plumbing's on the first floor. I'm going to have my architect testify now, and I'm going to ask him to get some more plans to be filed before the next meeting in regard to the removal of the bathroom on the first floor. So you'll know exactly what you're looking at.
I think we should have plans that show it in end state. What your plan is in end state. That's my comment. Mr. Stone, you're next. Ms. Rosenberg.
Yes, Ms. Cornell has something to say.
Hi, I just have a question. Is there a way, because I understand what it's like to stand in a room with rafters where you can't walk around and there's nails poking through. But I think for the general population, people that might not be able to visualize that, maybe if you could just take a picture of that area and show it to the board so that they understand that it's not livable space, that it strictly is for the utilities and whatever else might be up there. I think that would help people see exactly what you're talking about.
I think that's a good idea. I will get all of that done before the next meeting.
Thank you.
Thank you, Mr. Stone. Any other comments from the board? Mr. Stone, please call your next witness.
I'm going to call Alfred Trevino. Mr. Trevino, can you hear me?
Yes, I can hear you.
Is that you? I thought you didn't.
Yes.
I didn't know you were on the video. All right.
I wasn't actually. Now I am.
You're already sworn in. Would you state your full name and tell us your business or occupation?
Yes. Name is Alfredo R. Trevino, registered architect in New Jersey, Pennsylvania, New York. Have 32 years experience doing architectural, residential, commercial, light industrial, and apartment buildings. And I've testified in many townships before. over similar cases. Obviously, they all vary to some degree, but I have a lot of experience in the commercial and residential construction.
The board is pleased to welcome you.
Thank you. And it's the first time I do Bradley, by the way.
Welcome. Mr. Stone.
Yes, I was distracted, I'm sorry. Mr. Trevino,
Yes.
I know that you came in at the 11th hour with this situation, and at my request and the request of Mr. Murphy, it was necessary for you to examine the original plans. Am I correct? You saw the original plans for this building?
That is correct.
And then you saw that there was an effort at creating some as-built plans that did not conform to the original plans. Is that correct?
That is correct. Actually, we did the as-built plans as it stands now with, and then we modified the existing plans with some of the items that you guys are talking about for access to the attic.
Okay, so let's move on. All right. So, and at my request, you did this plan with the expectation that we were going to make an application for variances to approve some, but possibly not all of that which existed or was anticipated to be constructed. Isn't that correct? You understand that question? In other words, we're trying to figure out a way
That is correct.
We know that there's been some violations, and we're trying to either get a variance for some of the deviations, or at least try to get to conformity as much as we can. You understand that, right? So there's two areas.
That is correct.
There's two areas of my inquiry. Let's first deal with the first floor. Can you first, are you able to bring up your architect's plans?
No.
Larry, are you able to bring those plans up so that the members of the board and the public can see it?
I believe so.
These are the as-built plans.
Yeah. You remember the plans that you sent me before, Larry?
Yep.
For the use of the public, are these the plans marked 7/16/2020 that are on the website?
Yes.
Okay.
Yeah,
It's
everyone see that?
A1 and A2.
Okay. Are those the plans,
Yes.
Mr. Trevino? Okay, good. So let's
Yes, they are.
before we deal with the streetscape, let's deal with each floor separately. All right. So one of the things that I represented early in this application is that on the first floor garage level, there is a proposed bathroom. You see that there?
Yes.
Okay. And you heard my representation to the chairman and to the board members and to the public that it is the intent of the applicant to remove that bathroom. Is that correct?
That is correct.
Okay. And I also represented, without asking you, so I don't know how much trouble I'm going to get into, but I represented that we'd be able to do another set of plans timely enough so that we could send the plans into the board and to the board professionals showing the removal of that bathroom. Are you going to be able to do that for me?
Yes, I will.
Okay. So if the board were to approve this application, we represent that as part of the approval, as a condition of approval, we're removing the first floor bathroom, correct?
Correct.
All right. Now, let's deal with the third level, and I'm specifically characterizing it as a third level. Now, the issue there is whether or not that space is deemed livable space under the ordinance.
Well, let me just retract a little bit on that. Just by definition of a building code, anything that's not 7 feet and with the rafter ties, it will be 6'5". So just by definition, it's not living space, whether you like it or not. And it's not like any other attic that you can't throw a mattress up there and it's on an unfinished space. Obviously, people can do whatever they can do. But the thing is, by code, by building code, 6'5" under the rafters, it's not livable space. End of story.
Okay, so let's deal with this building. Can you describe for the members of the board, for the board professionals, and for the public, what is on the third level?
An attic.
How do you get to the attic?
Through a hatch, some place located probably in the existing closet, which would be less noticeable. We put a hatch that's 22 by 30. You move the access panel, and then you basically get up into the attic.
Will there be any mechanicals in the attic?
Yes.
And-
There'll be
and what-
the mechanical equipment will actually be up there, probably with some duct work all around, feeding the second floor.
So the height is too low per ordinance to make it livable, correct?
That's correct.
And with the rafter and the beams, you'd have to dodge, just like Mr. Murphy described before?
Yeah, but by definition, under the rafters, 6'5", under the building code, not habitable, period.
Okay, so now let's describe what it is that we put on this site. And maybe you can go from floor to floor and then describe the outside as well as the construction on the outside.
On the first floor, now that we got rid of the garage level, we got rid of the bathroom. You just have basically a garage door, a man door, and a set of stairs to take you up to the second level. You get up to the second level, you have a kitchen, a full bath, a closet, a dining room, and one bedroom, and then an attic.
Okay, and of course, and then the attic that you described. Can you also describe the outside from like a space?
Well, the outside is basically a gable with 2 shed dormers on either side, and then a double shed dormer up on the top, only for a portion of it, which is actually in the middle. So it's actually far back from the front, roughly in about the middle of the building. Let me just, yes. So basically with one window on one side and 2 windows on the other side, and they're just casement windows. Or actually, yes, not awning windows, sorry.
Okay, and that's pretty much it, isn't it? Anything else you
I'm
want?
sorry?
Anything else that you want to comment upon with regard to the structure itself?
Well, I think the dormers, I mean, you know, it's a preference thing for the attic dormers, and actually they're far back. So even though the elevation actually just shows them, because you're looking at straight elevation as if you were, you know, tall and you were looking at that, but actually they're set far back, and they're not the full length of the roof. It's only a small portion of it.
All right. Mr. Chairman, I have nothing further of Mr. Trevino.
Questions from the board?
I'd like to ask a question.
Mr. Quinlan?
Yes.
What is the square footage of the second floor and the first floor?
Hold on, I can't hear you. Go ahead, say it again.
What is the square footage of the first floor and the second floor?
They're identical. They're identical.
What's the number?
But you want to know what it is?
Yeah.
Hold on. Hold on. Let me just get to that. $600 square feet
for both each floor.
And the second floor is a little less because you don't count the well of the stair twice. So it's, you know, 600 less the well is there.
All right. Aren't you allowed 800 feet on the first floor?
I'm sorry, it sounds a little weird. Go ahead.
Aren't you allowed 800 feet on the first floor by regulation?
I'm not sure what's allowed because it's based on the impervious surface coverage, based on, you know, what's allowed for an accessory structure, and I wasn't privy to that.
All right.
Mr. Frieda, would you be able to opine on that?
Yes, the ordinance allows the first floor to be 800 feet. However, in this case, if they were to utilize that space, they would really be pushing upon everything else. The pool, separation to the pool, side yard, rear yard. So it wouldn't be, I think the sizes that's proposed or that's existing is appropriate.
Okay.
600.
Thank you.
May I ask a question, Mr. Chairman?
Sure, Mr. Stone.
Mr. Trevino, I just want to make sure, correct. I know that whatever enclosed space is on the third level, is there a cathedral ceiling in this building?
No, because well, it's not finished space, first of all, and it's, even though the roof rafters are sloped, when we put the collar ties, it will bring it back down to 6'5".
I see. I got it. Okay, thank you.
Any other questions of the board? All right, Mr. Trevino, question on the attic windows.
On the what? I'm sorry, I didn't hear that.
On the windows in the attic, how common is it to have 3 windows in non-living space?
For aesthetics, nothing else.
It's for aesthetics and nothing
At
else.
this point.
Yes. So it's strictly aesthetics.
Joke.
And
yes.
Okay. Christy, can you show me both sides of this, please?
And possibly ventilation for heat.
Okay. But if you're doing it for aesthetics, you got 1 window on one side and 2 on the other. You know, it's not as if when you look at the side of this building that, you know, and believe me, I'm not an architect, but when you look at the sides, it's not as if you're doing it for some type of uniformity.
Unfortunately. No, again, I mean, I didn't design this building. I'm actually just responding to the as-built. So I'm assuming this was just done so that it's not just a blank wall. So it's basically just for aesthetics at this point, and then ventilation.
Well, in the past,
Can you hear me?
In the past architectural pieces, there were steps leading up, correct?
I think it was a ladder, not really steps. There wouldn't be enough room to actually create legal stairs without taking up a huge chunk of the first floor, or the second floor, sorry. So there wasn't actually steps. It's actually a ladder, not steps.
Okay.
Mr. Chair, could I follow up with your question?
Mr. Frieda.
Yeah, I wonder, would the architect be agreeable, or would the owner be agreeable to removing the 2 windows on the one side, making it 1 as it is on the one side, and maybe that would make people feel a little bit more comfortable about it. The nice thing about the windows too is it lets light up in there. So if you had to go up for storage or to work on the mechanicals, there's some light that you can look around and see. So I think there's value to the windows, but maybe instead of 3, can we replace them with 1 on each side?
I'm going to recommend that to my client. If that's a suggestion that will assist in showing cooperation with the board, by all means, my client will agree to that.
Mr. Trevino, where do you anticipate the mechanicals going in the attic? As far as the floor plan?
On the floor, just on the floor. Yes. I mean, it hasn't been designed for the sizes, but actually it would be probably somewhere central, which is over the bathroom somewhat. And then the ducts beyond that, you know, they have to run on the floor to feed the spaces. I mean, I've seen attics like this, and basically it's a spaghetti up there with, and I'm sure you've seen them too, where you go up there and on the attic, and then basically it's a spaghetti of tubes going down, feeding the rooms.
Sure. I think as my colleague said, I think it would be helpful at the next at our next presentation to have a picture of what really is the situation there. With that, I have no further questions. Mr. Cohen.
Thank you very much, Mr. Chairman. Mr. Trevino, I was wondering, would it be possible, as I look at this plan, if you could keep that plan there, that would be helpful. Where we were, I have two questions based upon this. You're showing the first floor height to be a little over 9 feet. And then you're showing the second floor height to be a little over 8 feet, but you don't show exactly what the height is on the third floor.
I can give it to you. That's not a problem. It's 6'5" to the bottom of the. It's 6'5" to the bottom of the plate.
Great. Could you reflect that in your plan revision?
Absolutely.
Okay, great. That being said, to the chairman's comments, would it be possible for you to show the mechanicals in the attic? I
mean, normally that's not normally the case. I mean, architects don't do mechanical plans showing duct works and all that. I mean, we basically just refer, you know, to the attic and say, you know, that's where the unit's going to go, and maybe possibly the size of the unit. But we normally use just one-line diagrams to actually show where the ventilation is going to go. But we normally don't show the actual sizes of all. I mean, that's a whole nother animal that, you know, architects normally never get involved in that. I mean, that's a very usual request to do something like that.
Well, just to call out the space on the pen, you know, mechanical location. That's all.
Yeah, I'm just saying that's not normally what an architect does. We normally don't run, you know, ductworks and show every ductwork and the actual size. I mean, if anything, it's be a line diagram that says, well, this size is a 10 by 14 line, but we don't actually show the 10 by 14 and where it goes and what it feeds.
That being said, to get the mechanicals up there, if the roof line was lowered, could you still fit mechanicals up there?
Yes.
Okay, great. Thank you very much. Oh, I had one more question about the sliding glass doors. Did you ever see the original approved plan?
No, I did. Well, yes, I did, but actually, I don't know what actually has been specified. So I don't know. I'm not familiar with the specs of what has been approved, other than, you know, like 4 glass French sliding doors.
Well, on the original approved plan, there was actually no door at that location. There was a window. But could you tell me what the reasoning is for this big French sliding door to a storage area?
Probably just access, easy access for, you know, either kayaks or, you know, like.
But if there was a second garage door in the front, that would be an easy access also, would it not?
Yeah. I mean, I'm not saying that. I mean, any access into the garage, whether it's a triple garage door or a single garage door, a man door, and the triple, it's probably just to allow more light to come into the space, to give it more, you know, vibrance inside.
Mm-hmm. Okay. Thank you very much, Mr. Trevino.
Sure, no problem.
Questions from the public?
I think we tired everybody out.
Wait, there's a gentleman, he's just labeled as iPad. I'll ask him to unmute.
Hello.
Hi.
Hi. Your name and address, please.
Yeah, it's Thomas Daniels, 411 Brinley Avenue, Bradley Beach.
I thought, Mr. Daniels, before you.
Does the washer and dryer stay in the laundry room and the?
From what I understand, we're moving everything up.
No, the washer,
I'm sorry, yeah, you're right.
Washer dryer.
Washer and dryer is gonna stay, but it's just, so we're just gonna still leave the plumbing for the washer and dryer, but they're not gonna be enclosed in a bathroom.
That's correct. There's no
I-
bathroom.
I misspoke.
Let me just explain that. I was informed that my review said that the removal of the bathroom eliminated the use, but that there was no objection to having a washer dryer on the first floor.
Yeah, I remember okay.
Okay, so the washer and dryer goes to the first floor?
Stays where it is. Just stays
where it is. Okay, good. Where is the pool relative to the sliding doors?
I don't have a site plan with me, actually. Maybe Larry can answer that. That's actually more of a site engineering question.
All right.
Oh, there it is. Hold on. Larry, did you bring it up?
Can you see it?
I'm not seeing it yet. There, so we're, okay.
There you go.
All right, so you can hear me.
I can hear you.
It's here.
Yeah.
So the blue line is.
I don't see the picture.
You might need to change your view.
This is Jerry. If I could help, it's 7.5 feet away.
It's 7.5.
Right.
Okay.
The question was, how far away is the door from the pool? It's 7.5 feet.
So you could be inside the garage and you could see the pool, right?
Yes.
Oh, okay. Okay. So it could have that use also. And maybe that's why they wanted to have the bathroom there also. Sort of like as a pool house.
Yeah,
Okay.
makes sense.
Also, there are no collar ties in the area where there's a dormer. So the dormer.
It's not drawn yet.
Well, there can't be collar ties with the dormer.
Yeah, there can.
Roof's almost flat.
Yeah, we can do that.
How much does it reduce the size of the ceiling?
They're just gonna die in a different area. That's all. Instead of actually at the plate, they'll just die up at a little higher up.
Do you have a sense of how high?
6'5", I already said before.
Throughout. The inside. Okay. Well, thank you very much.
Wait a second. So what you're saying is the collar ties are going to run the length of the attic.
Yes.
The peak of the roof in the front, you're going to have 6'5" from the floor to the bottom of the collar tie.
If you're looking at the section,
sure,
you run a collar tie from end to end.
And you're going up 6'5".
And you're gonna go 6'5", and you're gonna put collar ties across.
Okay. Now
the other gables are not usable space.
Exactly. But
right.
to get at this gentleman's question, where is that 6'5" going to hit the wall?
Yes.
On the
dormers.
The dormer.
It's just going to keep on go. It's just going to go all the way to the front. It's just going to go 6'5", and we're going to run it right across in front of the high peak.
I don't think that's the case. I'm sorry. I'm not
No,
trying to
6'5" is the top of the plate. No. I'm saying the 6'5" is at the top of the plate. I know you drew a blue line way low, but that's not 6'5".
Okay. So what you're saying is the top of the dormer, On the
Right,
inside.
the top of the plate on either side.
The
We're
top of
running
the
a line
dormer.
straight across. It's 6'5".
If
Alfredo,
I
are you talking about here and here?
exactly right there, that's 6'5".
Hold on. Yes.
Okay. But then this is not drawn to scale.
It is. Yeah,
Well,
it is.
think about it. If you just draw a straight line across.
That's 6'5". From those yellow points to the floor is 6'5". Exactly the scale. We don't draw anything that's not the scale.
All right, draw me your line. Draw me your line across, your parallel
Right.
line.
That's
the
6'5" right there.
Okay.
You got it.
All right, now draw me your parallel line where the ties are going to go.
Alfredo, generally they're a third
Where
down
the attic,
from.
it's usually 1/3 down below the. This is probably going to be at 4 feet, I guess, on both ends. But where the collar ties are going to be at 6'5". There's a formula. This actually has to be more than 1/3 down below the peak. So it's going to be lower, 1/3 of whatever the distance is from the peak to the floor.
Okay, and then is 2/3 6'5".
And then and where we have the dormers, it's going to be a 6'5".
I don't know about that, folks.
Yeah, you know, with all due respect, Mr. Chairman.
Sure.
The architect is providing.
I mean, it's going to be less. I mean, it's a moot point because it's going to be less than 6'5". It's going to be at 4'5" or something. So what does
you
it
just
matter?
said
It's not
6'5". Is it 6'5" or 4'5"?
6'5", but on the other end, on the two ends where you actually have a steep peak roof, it's going to have to follow the formula of 1/3. I mean, you can't even crawl in that space.
So the only place that an average human being could stand is in the attic where the dormer is. Correct?
Well, but it's not habitable. I mean, yeah, you're right. I mean, a person is not 6'5", so yes, you could stand, but it's by code, strictly by code, not habitable. Period.
Gotcha. So in every area of that attic, I know you think I'm being difficult, but I'm actually helping you out here. In every area of that attic, the only place where a human being could feasibly stand is in the area that is the width of the room times the width of that dormer.
That's correct.
Okay, and how big is that space?
It's 19.1.
By what?
By hold on. Just going to get a dimension there. By 10 feet 4.
So it's 19 by 10 in that area.
Roughly, yes.
Roughly.
200 square feet.
200 square feet.
Approximately.
And I would assume because it's so well illuminated that would be the place that you would put the machine, the HVAC machine.
Yeah, that's the highest point, so you would think that's correct.
I think it would be helpful to have that in the architectural drawing.
Whether they buy a standing unit or a horizontal unit, you know, it depends. I mean, if they want to utilize it more for storage, they'll buy a horizontal unit that can lay on the floor.
I think that would be helpful to include that in the architectural drawings. And I understand that may not be standard procedure, but the fact that we're here in this situation is not standard procedure. Any other questions from the public?
I believe it's Brigitte McGuire again.
Ms. McGuire.
Hi there. Can you hear me?
Yes.
I just wanted clarification on the bathroom in the common area. Is it allowed or not?
Yeah, of course.
No.
Attic spaces are allowed.
No, in the first floor.
Excuse me, this is Jerry.
Thanks, Jerry.
The bathrooms are not allowed in the common space of the first floor of the garage. No bathrooms allowed.
And let's follow up on that so that this young lady knows we've already withdrawn the request for a bathroom on the first floor.
Okay. Thank you.
Any other questions from the
How did we
public?
build the bathroom?
I'm not
Yes,
seeing
this is
anyone.
Mr. Jankowicz, 507 4th Avenue.
Mr. Jankowicz.
Yes, when you say you're going to take the bathroom out, it's very easy to take it off a drawing, but physically, there's a lot more to take something that's physically built already. How do we know that the plumbing is going to be cemented off and you're not going to just rebuild it after we all leave?
The inspector will have to come and inspect it, that's all. I mean, they'll have to, cut the line off at that point and there'll be no line to it.
Okay, as long as there's some kind of affidavit that it's been
Well,
segregated.
that's what the inspections are for. That's why the inspector goes there and he reviews all that and he sees, hey, they didn't approve this, make sure that it's cut off. And that's what he does.
Mr. Trevino, to further effectuate your statement, could we ensure that the sewer line is removed from the floor? Because it's real easy to cap it.
Mr. Chairman, I can represent to you, my client just communicated and told me that there's no plumbing there now and there won't be plumbing there. I just got a text from my client, it's just as an explanation, the fact that we're doing this thing virtually, if we were in a room where I had a client sitting next to me, handing me a note, it becomes a little bit easier. But he just communicated to me that there is no plumbing there now, and he's not putting plumbing in there for a bathroom. And as far as the gentleman who said, is there going to be an affidavit? If the client represents that he's not putting a bathroom in, then that is enforceable. Because as a condition of approval, if the resolution says no bathroom and somebody puts something in after that, that's a violation of the resolution. And I'll defer to Mr. Kittrick and to your zoning and code enforcement officer.
So if this application were approved, that would be a condition of approval, and that would be in the resolution, and then it becomes then a code enforcement issue. So,
just so I understand though, on these plans here, it says existing bathroom, correct?
Correct.
And now we're saying it's not existing.
Well, it's existing.
The whole thing is a sham.
I'm really not trying to annoy you.
It's existing because that was what was on the plans, and that's actually what was as built. In other words, that's where all the pieces were actually going to fall in place. So that is the typical, when you go and survey an existing as-built condition, you would say that's actually the existing bathroom that they were proposing to put in.
But the bathroom wasn't on there in the original plan.
Well, but no, I'm saying this was an as-built. You got to understand, this was an as-built that was submitted.
I understand a lot, but the whole thing is jacked up.
No,
well, I understand that. I can only
I'd like to say something.
Mr. Jankowicz.
I don't appreciate that comment.
Mr. Stone, hold on a second. Mr. Jankowicz, this is not the time for comments about the application. If you have a question, ask the question. We're not interested in your comments until the application has been completed. Why are we not interested in your comments until it's completed? Because when you make your comment, you're going to be under oath, and you're going to be then providing testimony. So we don't want to hear your comments until you're under oath. Understood?
Understood. Thank you. And just give me the affidavit about the cementing of the plumbing. Thank you.
There's not going to be an affidavit. There's no affidavit. As I indicated before, if this, and I don't know whether this is going to be approved or not, but if it is approved, the resolution will state that they would not be allowed to put a bathroom in. And like any application, once it leaves this board, it becomes a code enforcement issue. That's what the code part says.
Other questions from the audience?
Mr. Januzzi has his hand up.
Mr. Januzzi. Wow.
Thank you. George Januzzi, 608 Evergreen Ave. A question, Mr. Trevino, when the discussion or the question came up about the sliding glass doors, I believe you acknowledged that that would potentially be could be used for easier access, which could be used as such thing like a pool house. And my question is a pool house a permitted accessory use under the Bradley ordinances?
Well, what is a pool house by definition?
Well, it certainly is livable or habitable space
Well,
on a
it won't-
first floor structure.
Yeah, but normally it would have a bathroom, a changing area. I mean, you don't want to have all glass and have exposed, anybody changing there. I mean, by what I would think, that is not a definition of a pool house by any means, especially since now there's not even going to be an enclosed room in there. The garage doors will be open, cars will be pulling in.
And
it makes sense.
Yeah, I would just acknowledge that the application states that the laundry will specifically be used for the pool. Towels, it's written in the application.
Well, it could be for the beach. I mean, who knows how they're going to use it. You don't want to bring all the sandy stuff into your house. You come in, you basically wash those towels from after coming to the beach. Why not?
Well, I'm just pointing out that it was acknowledged that it would be used for the pool in the application. So I think that should be considered.
I'm just saying, but now that
keep it to questions, folks.
Now that there's not going to be an enclosed room, there's no more privacy.
Any other questions?
I have a question.
Mr. Daniels.
Yes. So the laundry remains, but the walls are taken out?
There's no laundry room. It's just a washer dryer.
They're just sitting there.
The walls are removed. Are the walls removed?
Mr. Daniels, I think we're going to see clarity at our next meeting.
That is correct.
With the new drawings.
That's correct. We'll just get rid of the walls, and they're just going to be a washer dryer sitting in the room, in the garage.
All right. I look forward to seeing the drawings.
Please leave it to questions only.
Thank you.
Any other questions?
I have a question.
Ms. Katowski.
Yes, Cindy Kwiatkowski, 200 Ocean Park Avenue. My question is, in the existing garage, is that now a solid wall for where the storage area would be?
It shows it the way it shows it on the plan. I'm not sure which wall you're talking about. The front wall has a garage door and a man door. On the left side, there's one window. On the back side, there's going to be still one window. On the right side, there's going to be the sliding glass. So I'm not sure which solid wall you're talking about.
It appears there's a line coming down the center of the garage where right through the word exist. Is that a solid wall?
That's a dimension line.
Okay.
And you can actually every time you see a number in front on top of it, that means it's just a dimension line to tell you what the distance is from one area to another area.
Okay. So the area where the sliding glass door is, you're suggesting that that would have no privacy, yet you're suggesting that would be storage that anyone could see into where you're storing personal valuables.
Yes.
Okay, thank you.
Any other questions? Mr. Murphy? I'm sorry. Any other questions?
Brigitte McGuire.
Ms. McGuire.
Sorry, it's under Thomas McGuire now. We switched roles. I was driving the time. So my one question is—
What's your address?
Oh, sorry, 610 Brindley Avenue.
Thank you.
My question is about, we've been talking about removing things. Can the dormers be removed?
Anything can be removed. The whole building can be removed, of course. It's like a hypothetical question.
That's not hypothetical. There's an there's something that shouldn't be there.
Anything can be removed.
So then can we remove the dormers?
The purpose of this, I'd like to answer that. The purpose of this application is to get the building approved as it exists with minor alterations. That's the purpose of being before the board, to get variance relief.
Okay, so aesthetically, since you're the architect, and I know you did it as the as-built.
I'm not the original architect. The original architect passed away. I actually took on this project after this is as an as-built on the 9th hour here.
Okay, I understand that. I just want your professional opinion is as doing the as-built, and if you were to remove the dormers on there, would it still be aesthetically pleasing?
It wouldn't be as interesting because obviously that actually, every time you actually have a dormer and windows, it actually just has another element of architecture. So, you know, I would say more dormers, more interest, more, you know, and again, it's all depends on the individual, you know, person. But to me, it adds interest.
So it add interest for the person walking by, or is it for the actual
for the homeowner? It's for the homeowner. They don't, you know, it's all this stuff is done to custom for the owner, not for the, you know, like for, oh yeah, you're gonna like it. I mean, if the owner likes it, then you know we built it. I mean, that's just me not having to do with this project.
Would it provide more air and light?
Or what?
Air and light, the dormers.
I'm not sure I understand the question.
So if you don't have a dormer there, there's no area to put a window, correct? So then by adding the dormers, you're adding light and air, correct?
That is correct.
Okay. So again, do I have any more questions? Because I don't want to lose my opportunity with you and get in trouble. I think that's everything, but thank you for answering the question about the dormer, because I really think, no, I can't leave the comment. No comments. Thank you.
No comments. Thank you, Mr. McGuire, for withholding.
You're
Any other
welcome.
questions? No more questions for the public for Mr. Trevino.
I don't see any.
Mr. Stone, do you have any redirect?
I don't. I think that's okay. In fact, when I bring them back the next time, the plans will be a little bit different. Right. And I think that will add some clarity. The only thing I would say, if we're going to end here now, I want to, since I have my experts on sound now, I will call you tomorrow so we can assemble what we have to provide to the board in anticipation of the next meeting. And Christy, if you want.
Too late.
What? What'd you say?
Go ahead, Mr. Stone.
It was somebody from the public.
Oh, nice. What I'm going to do is, Christy, I don't know if you need me to sign anything to approve going into the November meeting, but I'll waive any time requirement.
I think as long as you have it on the record, we're okay.
Okay, and what I'd like to do, I'd like you to keep us on in November and certainly put us on in December. I hope I'll get some priority in December, so we'll be number one, and hopefully we'll be able to get some time in the November meeting.
Yes.
Mr. Stone, it is certainly my desire to get this as resolved as expeditiously as possible. I know your clients have been waiting. In all fairness, we want to make sure we get it resolved. Do we have comments? Are we doing comments from the board first?
Mr. Cohen has a question.
Mr. Cohen, this has to be limited to questions raised based upon what council has directed you.
No, actually, I was going on procedure, Mr. Chairman. My planner is available on the November and the December dates. I just wanted to clarify.
All right,
excellent.
Thank you.
Mr. Kittrick, comments from the board or comments from the public?
No comments from the public. We'll do that at the end of the testimony.
Yeah, I have a question of Mr. Cohn. Mr. Cohn, does your planner have a report that he's provided to you?
Not at this point, because your application has been presented in a fluid nature with multiple changes, Mr. Stone. Don't forget, we entered this room with a use variance. Now we don't have one. So I don't want to present redundant material. So my planner will present their report when you're finished with your testimony.
Will you provide me with a report in anticipation of his testimony or her testimony?
No, her testimony on the record will be the report.
Okay.
Mr. Kittrick, are we okay with this?
Yeah, that's fine. He has the right to do that. There's no, Mr. Cohen is not under any obligation to have his planner prepare a written report. That's perfectly acceptable. He can, certainly can rely on his case in chief with the testimony of that planner. That's totally permissible.
Okay, so with that, Mr. Kittrick, if I'm not incorrect, we will adjourn for the evening, carry the matter until our November board meeting.
Which is what
November.
date again?
November 19th.
Okay, so just to let everybody know, carry till November 19th with no further notice. And I'll leave it to you, Mr. Chairman.
And the December meeting is the week of my 75th birthday. Anybody expecting to have anybody expecting to have a party for me?
No COVID party for you.
With that, folks, I thank the members of the public. I thank the professionals and everyone involved here. I understand this is a matter of great interest. We all here take our responsibilities seriously. The matter is carried, and I will entertain a motion to adjourn.
I'll make a motion to adjourn.
Second.
All in favor?
Aye.
Aye.
Thank
Those
you,
opposed?
folks. See you next
everybody.
month.
Thank
Be
you, Mr.
safe.
Chairman.
Good
Thank
night.
you.
Good night.